Yes. Good morning, Mr. Khaled. I hope you are well this morning.
Hi, Annika, thank you. Same to you. I'm well. And you?
I'm good, thank you.
Good.
Good morning, Mr. Khaled. Annika speaking here. I just wanted to check, may I assign the hosting rights to you for your presentation?
Oh, thank you. Certainly. I'll just get that ready because I thought that you would be presenting, but we'll just get it up and ready for the presentation. Thank you.
Okay, we'll
Thanks
do.
for that.
Recording in progress.
Chair, good morning. It looks as if the committee members are under the impression that we only start at 9:30 as usual, as it was in the past, because it's only you and I on the platform.
Morning. Let me check with the committee secretary. Are we ready to start? Content advisor, Dr. Clark.
Yes, good morning, Chairperson. Are you well this morning?
I'm good. Good.
Good. We're just on the sideline trying to get
That
some of the members.
I'm trying to check, see the notice sort of create confusion in terms of 9:39. the one for the agenda says 9, but the link says 9:30. So I just needed to check how many members do we have on the platform?
We have yourself, Honorable Member Boshoff. That's how many members we have in so far, Chairperson.
Yeah, I think let's
Mr. Brotas has just joined us now.
yes, let's round up members just because I suspect the two notices, the one that says 9:30, the one that says 9 could create a bit of confusion.
Yes, Honorable Member Mashodi also joined us now, Chair.
Okay, good. Let's just wait for 5 minutes before we start. Yeah.
Chair, Mr. Brotas has a hand.
Yes, Tim, how are you?
I'm okay, Chairperson.
I'm good.
Chairperson, I just have a difficulty. I have a difficulty this morning. Unfortunately, I have another very pressing commitment at 10 o'clock.
All
So
right.
from the nature of the agenda, it appeared that we were just receiving submissions today. Is that correct?
That's correct. That's correct. And responses?
Okay. Yeah. All right. So we're not voting on anything today.
No, not voting on anything.
But in any case, we're in favor of these bills, Chairperson. So please just
Okay.
accept my apologies if I need to log off around 10 o'clock. I do
Thank
apologize. You know, Chairperson, it's just that time of our 5-year cycle. I'm sure you understand.
They're great.
All right.
Thanks.
Thanks, Pete. Appreciate it.
Thanks.
You too,
Yeah.
Chair. Increase the volume. Yes.
Honorable members, I think it is time now for us to formally start our meeting. Let's formally open this meeting by extending a word of welcome to all of you. We know that it is a bit of a hectic time this time of the year, appreciating the fact that on the 29th of May is a general election, and at the same time work has to go on. We have a responsibility to make sure that the bills that are on our desk are processed, and therefore but will be economical in terms of time, but also being efficient to ensure that work continues. We'll be dealing with two bills, the Transport Appeal Tribunal Amendment Bill and also the Railway Safety Bill. We will be receiving the written presentation in terms of this bills. The department will also be responding to the railway safety bill. But I think what we'll then do, we'll just also make a reflection probably in terms of some of the provinces that are impacting our programs in terms of their hectic schedule. But in terms of the agenda, as indicated, we will get a presentation from our content advisor, Dr. Clark, and then also the clarifications, and then it will be then Dr. Clark again on the presentation, then get the stakeholders that gave us their views in terms of the bills, and then allow then the department to then respond. We might have to probably then get a sense in terms of the process moving forward. But be that as it may, let me then also greet all our stakeholders that are on the platform, the department, and also the representative of various companies that will be doing presentations, and also the federation. Greetings to the leadership of the federation that will be making presentation, and then the parliamentary staff, the public, and the parliamentary communication staff. Let's then formally get a sense from the committee secretary in terms of whether we have sufficient members on the platform. Committee secretary.
Good morning, Chairperson, and good morning, honorable members, colleagues, and our stakeholders. We do have sufficient members on the platform because I see 5 members so far. It's yourself, Chairperson, Honorable Boshoff, Honorable Khai, Honorable Moshodi, Honorable Brotherfest.
Thank you.
We can proceed. We have also received apologies from Honorable Mama Rekhane. She's attending the SC on finance. She will join us later. Rather, it's not SC on finance, it's the Wipari meeting. Yes, she'll join us later. And also
Honorable Mama Rekhane and Dango.
And Honorable Dango, who's attending the meeting in the province.
Thank you.
Thank you,
Let's
Chair.
then note those apologies, honorable members, and then move to the next item on the agenda, which will be the Transport Appeal Tribunal. Dr. Clark.
Good morning. Thank you, Chairperson, and good morning to everyone on the platform. The first bill that's on our program is the Transport Appeal Tribunal Bill. So the objects of the bill, just to remind you.
Chairperson?
Yes, Committee Secretary.
I will request Dr. Clark to record the meeting because today she's the host of the meeting.
Oh.
Yes.
Dr. Clark?
So, okay, let me do so. Let me just stop share.
It's sorted.
Thank you. Back to you, Dr. Clark.
Thank you, Chairperson. So the first bill on our program is the Transport Appeal Tribunal Bill. The objects of the bill is to amend the Transport Appeal Tribunal Act so as to insert, delete, and amend certain definitions, to bring the Act in line with developments since the enactment of the Principal Act, to provide for certain powers of the Transport Appeal Tribunal, members, that being the tribunal that deals with applications for operating licenses, to empower the Transport Appeal Tribunal to make appropriate steps in cases where its rulings are not implemented or effected timeously, and empower it to investigate delays in the completion of its proceedings. Members will recall that the tribunal operates as a quasi-judicial body, effecting rulings after it has undertaken its processes, and also to provide for matters connected herewith. The bill was passed in the National Assembly, transmitted to the National Council of Province for concurrence, and referred to the Select Committee on 7 March 2023. Members will recall that the Department of Transport on 18 October 2023 briefed the committee on the objects and the various provisions of the bill. And on March 2024, an advert was placed in national media calling for written submissions on the bill. The deadline for receiving submissions was 12 April 2024. No submissions were received on the bill, Chair, and also no request to address the committee on the bill was received. So, Chair, I don't want to belabor the point, but that is the process so far on the Transport Tribunal Appeal Amendment Bill. Thank you, Chair. You are muted, Chair.
Just the process in terms of moving forward, Committee Secretary, before I allow members for clarity.
Chairperson, the process moving forward, then it will mean that we will wait for the provinces now to send us the negotiating mandate. Then after receiving the negotiating mandate, then we will process this bill through those, we'll process those mandates, then final mandate.
Yes. Okay, thanks for that. Any clarity, questions from members on the process thus far, given the fact that we have not received any written submissions? Perhaps maybe the other question will be in terms of indications from provinces other than Eastern Cape. What is the take of provinces? Are they managing? Will they manage in terms of our outline program?
Thank you, Chairperson. Yes, the provinces are managing and they will manage, Chairperson. We will complete this bill.
All right. No, thanks. Thanks for that. Honorable members, any clarification questions on the process thus far? Take that members are fine in terms of what has been outlined thus far, because we did not receive any written submissions. And then we are waiting for the provinces to give us the negotiating mandates. And once that has happened, we'll then probably then get a sense from both the department and the parliamentary legal advisor on this on the mandate as indicated by provinces before we finally sit for the final mandate and the report. Next agenda on the next item on the agenda. The Railway Safety Bill, Dr. Clark.
Thank you, Honourable Chairperson. The next bill on our program is the Railway Safety Bill. The objects of the bill is to provide for the regulation of railway safety in the Republic, to provide for the continued existence of the Railway Safety Regulator. Chair, so there's already empowering provision in terms of which the Railway Safety Regulator has been established. This Act will make provision for its continued existence. To provide for the board and governance structures of the Railway Safety Regulator, to provide for railway safety permits, to provide for railway safety critical grades and safety management systems, to provide for National Railway Safety Information and Monitoring System, to provide for a legal framework to enforce compliance with the Act and to deal with railway occurrences, to provide for an appeal mechanism, to provide for transitional arrangements and the appeal of the National Railway Safety Regulator Act, and to provide for matters connected herewith. The bill was passed by the National Assembly and transmitted to the NCOP for concurrence and referred to the Select Committee on 24 October 2023. The Department of Transport on 15 November 2023 briefed the committee on the objects and the various provisions contained in the bill. On 18 February 2024, an advert was placed in the national media calling for written submissions on the bill, with a deadline of 25 March 2024 for receiving written submissions. The Select Committee will today hear written submissions received, as well as the department's response thereto. Inputs were received from 6 stakeholders. The first 4 stakeholders are with us today and will be addressing the Select Committee on their submissions. Those are the Concerned Engineers Group, Congress of South African Trade Unions, Gauteng Management Agency, and the Bombela Concession Company. The last 3 stakeholders that provided written submissions is the Western Cape Government Department of Mobility, Mr. von Gericke and Mr. Kohlberg. I will be presenting the committee with a summary of the inputs provided by the last three stakeholders. But I do not wish to duplicate Chian Committee, as the Department of Transport will later on provide detailed responses to the written submissions received. So I will be focusing more on the inputs that has constitutional implications, Chair and Committee, as well as inputs that relate to the concurrent and exclusive functions of the various spheres of government. So I turn first to the Western Cape Government Department of Mobility submissions. The department supports the bill in principle, subject to the comments and the recommendations that they have submitted. There's an overarching input in respect of the general comments that the bill lacks proposals to combat rail infrastructure vandalism and acts of criminality. To address this, the department recommends that what is needed is clearly differentiated primary and secondary roles and responsibilities of key stakeholders necessary in dealing with all safety and security arrangements in the rail environment. This includes clearly defined roles that can be encapsulated in formal agreements to be reached between the relevant heads of Transnet and PRASA, the South African Police Service, and Metro Rail. The need to define roles and responsibilities is also needed in respect of the arrangements for persons with special needs. So specifically the redeployment of station infrastructure, the redevelopment of station infrastructure and rolling stock to be user-friendly for persons with disabilities, as this translates into high costs. And the cost needs to be shouldered by the property owner in the view of the Department of Mobility, and not the operator of rolling stock, which is the Department of Mobility's view, with rather reading of the bill as it is currently. And that the cost-benefit analysis to be undertaken in terms of the Public Finance Management Act should then be undertaken by the property owner. Clear roles and responsibilities are also required in respect of risk assessments that must be undertaken. And the Department of Mobility's reading of the bill is that the rail operator is expected to be primarily responsible for the safety of rail commuters. Roles is also required in respect of overcrowding. And here again, the Department of Mobility's reading of the bill is that matters related to overcrowding rest on the shoulders of the operator. Clear roles and responsibilities are also thought to be necessary in respect of theft, malicious damage to property, and other criminal acts. The Department of Mobility's reading of the bill is that it creates the impression that the rail operator can be primarily held responsible for such matters as theft, malicious damage to property, and other criminal acts that impact on safe railway operations. Their views this is not correct, and that no attempt is made to specify the primary responsibility of the South African Police Service in terms of the safety of commuters on trains and stations, and the primary responsibility of Transnet and PRASA as owners of property in the rail environment, being the fixed and the rolling stock, to safeguard such property. Clause-specific inputs. Clause 4 provides for exemption upon application from compliance with any provision of the Act other than Section 4. The Department of Mobility's view is this clause is problematic as it is not definitive and prescriptive of what could qualify as criteria for an exemption application, and that this is necessary to reduce unnecessary applications, and it might open what we'd call a floodgate to frivolous applications and create unnecessary administrative burdens around the processing of exemption applications. The functions, in respect of the functions and powers of the regulator, as set out in Clause 7, the Department of Mobility is of the view that in its current form, the bill does not sufficiently emphasize that the operational capacity of train freights and commuter trains should be focused on, and that in terms of commuter trains, a report must be provided on a monthly basis of actual operational capacity. In respect of Clause 10 and the composition of the board, the Department of Mobility is of the view that the composition of the board should include members that have extensive experience in the field of policing, security, or law enforcement, in line with their broader recommendation that clearer roles is required in respect of both safety and security. The department also notes that the Department of Public Enterprises is not included on the board of the regulator, despite the department being a key stakeholder in the rail sector, considering its oversight role over Transnet. Clause 25 relates to limitation of liability, and the Department of Mobility notes it with great concern that in terms of Clause 25, the state and other associated entities are not liable for any loss, damage, or failure to exercise any power or perform any function in terms of the bill. And that the existence of such a provision in the bill does not further any serious aims to transform and ensure accountability on the side of the state. No measures are in place in the bill, in the department's view, to hold the regulator accountable for its actions or omissions. And the regulator is absolved from the liability, whereas the operator not adhering to the regulations is committing an offense. And in such circumstances, the Department of Mobility views accountability in the bill as appearing to be one-sided. The next input is from Mr. van Gericke. He has a background in research, design, and development in the railway sector, in fact, having worked for Transnet for quite a number of years. Mr. Gericke's input relates to the rolling stock that will be deployed on our railway network, and that when third-party access is being implemented, companies that will need wagons could possibly acquire wagons from manufacturers which are not able to manufacture to Transnet's requirements. And this, Mr. Gericke says, is a threat to public safety. So Transnet has issued specific standards and requirements, and Mr. van Gericke helpfully provides in his annexures a copy of specification standard BBD 8678. His recommendation is that the definition of technologies, meaning the technologies that may be deployed on the railway, should be amended to state that the Transnet specification standards and requirements should be adhered to. Under objects of the Act, Mr. Gericke also recommends the inclusion of a subsection G, which should specify that the objectives include ensuring that rolling stock are in accordance with Transnet standards and specification. The last input is from Mr. Kolberg, who is a community member living adjacent to the Groenwater station. Mr. Gericke's input is that the bill must instruct or direct transport that wherever the trains operate, the railway must be fenced in order to secure the safety of passengers and animals. Chair and committee, one can really look at Mr. Kohlberg's inputs as what the results are when existing legislation and regulations are not implemented as it should be. So it gives an example of the Groenwater Stasie where animals have been lost due to Transnet trains, and that to date no one has been held responsible at Transnet. He refers to Groenwater or relates to as Groenwater as being a marginalized community. And to his view, the community has been left poor by Transnet, and that there's a need to legislate precautionary measures, and that these legislative measures should be implemented. He proposed in respect to that community itself, a bridge that must be built by Transnet so that the community can cross over the bridge for the animals. Mr. Kohlberg suggested 5 to 10 meters of fencing or an appropriate space of fencing away from the train. Chairperson and committee, that is a summary of the written submissions received. Thank you very much.
Thank you, Dr. Clark, for taking us through the process, but also then venturing into a summary of representations that were made by the stakeholders that you indicated. I believe of critical importance is to appreciate the time that the stakeholders took to honor the invite that we made to them in terms of comments. What we will then do, let's probably also take this opportunity to get a sense from the members. I want to believe they will. What they will do? They must have jotted those clarification questions down for engagements later, and then take this opportunity to then invite those companies that you indicated that they will be making oral submissions. Like as you indicated, we have the concerned engineers group. We will get an indication from the group who will be taking the podium, just to again reiterate the fact that each will be given 15 minutes to deliberate, to put their case across. And then once that has been done, we will then get clarification questions again from members in terms of all the presenters. And then thereafter give the department an opportunity to give their response to both written and oral representations. And without any waste of time, let me give over to the concerned engineers group. Who's leading the team?
Will lead the team, Mr. Chair. Thank you very much.
Thank you, Mr. Kalat. Welcome and greetings to yourself. You can now take the floor.
Thank you very much, Mr. Chair, honorable members, and thank you for the opportunity to present our submission to this committee. I'd also like to say thank you to my fellow colleagues who are part of this group as well and also attending. We're a loose association of a group of concerned engineers, primarily ex-railway, concerned with railway safety, life cycle asset management, and the role of professionals in railway management, railway occurrence investigations, passenger safety, and the ruination of public infrastructure. Collectively as a group, we have extensive railway experience in the manufacturing of railway vehicles, performing accident investigations, and compiling the guidelines for boards of inquiry, presenting lectures on accident investigations, and compiling the lecture materials for accident investigations. We've attended court cases on passenger safety, and we are a study group with informal representation of a large, I use the informal phrase, Spoories WhatsApp group. History has molded our experience where historically the railways were exempted from the Factories and Machineries Act. In this environment, the railways, as asset owner, was both accountable and responsible for safety. They were the judge and the jury in that they compiled their own specifications, standards, and operating instructions, and investigated themselves. When the Health and Safety Act, Act 85, was promulgated, members were appointed as inspectors on the railways, and of these members were instrumental in laying the foundations for the safety chair at the University, Pretoria. It is not the intention with this slide to present a lecture on asset management in all its details, but to use the slide to demonstrate the depth, breadth, and scope of life cycle asset management. It serves as a foundation for the next slide, where rail safety aspects are highlighted. From this slide, it can be seen that safety-related aspects occur throughout the asset management life cycle, from the strategic phase through the project creation phases and into the operational phase. This slide underpins our contention that safety is an integral part of the life cycle asset management system and is not a bolt-on in the operational phase. I'd now like to move to the general comments of our submission. And it is our view that the bill approaches safety as a bolt-on rather than an embedded state. This should be addressed in the preamble, where safety is a desired state that embodies all processes and interfaces. The point was not in our written submission, but we believe that the bill should also apply to rolling stock leasing companies whose assets will traverse the railway network. We further submit that the bill should include educating the public in railway safety. In particular, this should be the public immediately adjacent to the railway reserve and ideally targeted to the youth, where hopefully they will develop an appreciation of the dangers of the railway operating environment. To achieve the objects of the bill, we submit that persons appointed must have the necessary qualifications. Professionally qualified persons should be appointed to manage the life cycle of their assets in the form of ISO/SAN 55000 standards. Finally, the regulator should verify and report on the functional condition of their assets and their deterioration and improvement over a reporting timeline. Turning to the board and the chief executive officer, we hold that the board must maintain and develop a board competency profile. The word competency is inserted as it is considered essential for fact-based analytical discussions leading to informed decisions demonstrating a comprehensive understanding of the rail environment. We hold that it is not just sufficient for the board to develop a profile of competencies without it being a requirement that the board actually possesses those competencies. It is inevitable that disagreements will arise, and should a board member believe it necessary, the member may record his or her objection to a decision and report the objection in writing to the minister and his or her professional institution. This is in the interest of transparency and professional integrity, as well as informing the decision-making process. The board may be dissolved when the asset condition and/or safety record has deteriorated beyond international norms. In this case, in the absence of proactive steps, the board would have failed in its duty. We further hold that the CEO may be dismissed for misconduct or incompetence. Incompetence is added as it generally manifests itself over a period of time, but it may also be a singular event. Finally, the CEO must submit all strategic and procurement documents or policies to the board to comply with the public procurement. On the limitation of liability and reporting, we hold that the limitation should exclude gross negligence and dereliction of duty. We believe the phrase currently used in the bill, in good faith, is too broad and lacks precise definition. The defense of honest belief as a proxy of good faith must be subject to the test of reasonableness concerning the individual's knowledge, experience, and competency more generally. The precise meaning of good faith remains a matter of construction, having regard to the specific context in which the defense applies the nature of any power conferred. Gross negligence and dereliction of duty create a more defined context for evaluating an action or inaction. Furthermore to this one, we hold that the condition of assets and the rate of deterioration and or improvement with the concomitant risk to railway operations must be reported to the Minister. On the safety critical grade framework, numerous additions are proposed relating to the qualification and registration as it relates to professional persons. Further, a safety critical grade in the bill is defined as a work position responsible for the authorization and control of the movement of rolling stock. However, authorization and control of the movement of rolling stock does not include the declaration or certification that the track and control systems are safe for the passenger trains, or that the rolling stock is safe for movement on rail. And this relates to previous items just recently spoke about. A clear distinction should also be made between the activities covered by this bill and the Health and Safety Act, Act 85, which is still considered to cover personal safety. With regard to the safety management system and safety information and monitoring, we hold that lifecycle asset management system should be applied by the asset owners, must conform to ISO SANS 55000. This standard may be specified in the regulation. We argue that a reasoned lifecycle asset management system is integral to ensuring assets are service-worthy and safe for operations over the functional life of the asset. This accords with our systemic approach to safety. The safety system should also include information on the functional condition of the assets, remaining useful life, historical deterioration or improvement rate, and their safety level. In respect of major investigations, these should include a call to provide evidence with the depository for open or closed information to assist in the investigation. The information contained in the findings report may be confidentially classified by witnesses and shall not be used in any criminal proceedings arising out of the occurrence. This is similar to the National Transportation Safety Board, which investigates every civil aviation accident in the United States and significant accidents in other modes of transportation. Here, the board seeks to ascertain the root causes and makes recommendations aimed at preventing future accidents or occurrences. And finally, and this may be in regulations for SADC and for the South African Development Community and train operating companies, SADC and TOCs, and it is similar, it touches on the representation by Mr. van Gericke, that SADC and TOC rolling stock must be railworthy per SANS 3000-3, which cover the technical requirements for engineering and operational standards, rolling stock, and SANS 3000-6, the interoperability, intermodal, and utilities management. Here they comply with Transnet specifications for private-owned rolling stock on the Transnet network, taking into account that this is currently have a network statement out for Transnet by the Rail Transnet Infrastructure Manager. And finally, the rail safety regulator should guide on the registration of train operating companies' rolling stock to the Luxembourg Rail Protocol Register. Thank you, Mr. Chairman. That concludes our presentation for this morning, and thank you very much.
Thank you, Mr. Karat, for the presentation. Like as we indicated, we will at the right time ask members to engage with your presentation. Just clarity question, because this is not meant to be an interrogation. It's just clarity seeking questions. The department will respond to the issues that we are raising. Thank you for the opportunity that you took to make us appreciate the angles from where the concerned indigenous groups' views comes from, and we appreciate that. Having said that, let me then take this opportunity to then invite Mark from COSATU to also take the podium.
Morning, Chair. Morning, honorable members. Let me just share. Thanks for always giving us space, Chair, just to share our views.
Thank you.
Honorable members. And I think, yeah, one must appreciate that honorable members are really doing the graveyard shift in the last few weeks of this administration. So we always appreciate the effort members put into issues. I think, Chair, just to highlight a few issues. Look, railway safety is important for workers who run the trains, but also for workers who use trains to get to work. And of course, workers who work in industries which depend upon a smooth functioning transit freight rail as well, and workers who live in working class communities too. So I think overall, Chair, it's been a long journey. I think it's almost 8 years now, I think, roughly, memory serves me right. And we do support the bill. We think most of its provisions are quite progressive, and we do support its passage. There are a few clauses which you are concerned about, whether they are silent or a little bit vague, or just a bit worrying on unintended consequences. I think in particular the fact we're very sensitive with Labour on the issues of collective bargaining. We do think the clauses there are a little bit worrying. We also feel that the clause on the issue of the consultative forum is a bit vaguer on its composition. And also with regards to boards meetings, there's no fixed requirements for when boards or half of the boards at least should meet. We were also a little bit surprised, Chair, that the clause around enforcement inspections are limited in most instances to working hours, and that for us was a bit strange. There's some clauses which are specific that employees don't have the right to appeal to the CEO or to the Board Appeals Committee, and a specific that is prohibiting employees, which didn't make sense for us. And then, Chair, just in a broader context, we feel the bill doesn't really speak to the issues of safety affecting commuters or pedestrians at railway crossings or sidings and railway lines. And of course, we felt it wasn't really speaking, maybe necessarily decisive enough with regards to the pandemic of copper cable theft and arson and vandalism, which are really crippling our railway network. Chair, look, in an introduction level, we support the bill, but of course, some of the parts we're a bit concerned about. We do think this is an ideal opportunity, albeit, at 5 minutes to midnight in the parliamentary calendar, to see if we can't further tighten the bill. But ultimately, we need a very strong bill, which is really going to empower Metro Rail and Transnet to make sure and hold them accountable as well around railway safety issues. So we do hope that Parliament would, consider our proposals, and we hope they would assist members in their work. We do look forward to the bill being passed, again, but just to sufficiently strengthen it. We support the extensive mandate and the powers given to the regulator, inspectors by the bill. We think these are quite critical, including the issue of withdrawing permits, shutting down operations, inspections, search and seizure powers. Ultimately, if you want to be able to enforce the law, then the inspectors must be fully empowered. We think this is going to be critical to helping them to fulfill their mandate. Chair, with regards to the composition of the board in clause 10, this has been a point of concern for us, but we are quite happy that in the National Assembly amendments, our concerns were resolved on this issue. So there is now provision for representation of organized labor. We think this is critical to ensure maximum buy-in of labor in terms of railway safety, and the challenges are dealt with speedily. Workers who run the railways, Chair, they've got extensive experience in railway safety, and of course, we think they're going to add invaluable expertise. We think also, Chair, it's fundamental these representatives should be selected by workers, by labor, which is the norm. They shouldn't be simply selected by management, because that will undermine the ability to speak honestly, etc., etc. Chair, there is one concern with regards to clause 15D 1 and 2 under the disqualification from appointment as a board member. So the clause basically prohibits anybody serving the board if they're employed by government, whether it's in the public service or any other organ of state. So, Chair, that would mean that's going to raise complications for worker representation. So it would mean now, in a sense, that if a worker is employed by Transnet or Metro Rail, they wouldn't be allowed to serve on the board. We think that's really going to deny us people who've got a lot of expertise and experience in railway safety. And this, of course, would also disadvantage the board too, which you would really want to have people who are really well-versed experts that have got practical experience and ideas and solutions, etc. There is an exception clause already in the bill which is applied for government representatives on the board. And we think simply, Chair, that should just simply be extended to the worker representatives. So a proposal for clause 15D2 is that we simply extend this exemption clause for government representation on the board to also include labor representation as well. So it wouldn't prohibit somebody who is an employee of Transnet or Metro Rail or whomever, often might be a shop steward for serving on the board, because you really do want, as the previous colleague had mentioned, people with great expertise and experience. You don't want people just going to come and speak around generalities. Then, Chair, just quickly on administrative kind of issue on meetings of the board in clause 17. So silent upon how often the board should meet. And that might seem mundane, but we have experience in other boards of boards not meeting at all for months at a time, maybe even for a year. So if we don't specify how often the board should meet, at least perhaps quarterly, then how would the minister be able to hold them to account? And we think, given the crisis facing Transnet and Metro Rail around copper theft, vandalism, arson, etc., etc., we should at least stipulate for the board to meet at least quarterly. You don't want to get to the other extreme of a previous SABC board, which was meeting weekly to collect per diems, but at least quarterly, I think, is a reasonable ration, and that's normally what happens in other legislation. Then, Chair, in terms of the staff of the regulator, the clause 23, 2A, as well as 3 and 4. So it basically just says the board would determine the terms and conditions of appointment of the staff members of the regulator. The minister, with the concurrence of the Minister of Finance, should approve any increases for the staff to the salaries. And the board can also establish and manage a pension or provident fund, as well as a medical aid scheme. And those might seem fairly simple, but our concern is basically a couple-fold. One is that it's silent around workers' constitutional right to collective bargaining or even to be engaged on the conditions of service. Normally, other legislation does kind of just mention that. But we mentioned that, Chair, because we do have experience as Labour in both the public and the private sectors of employers often just simply choosing to ignore collective bargaining, just simply choosing to impose agreements, etc. We think it also undermines the tradition which already does exist of collective bargaining of a transit, a metro of the regulator, etc. And then, Chair, just in terms of establishing a separate pension and medical fund, we're not sure that really does make sense, given there's not a huge amount of staff complement. There are already existing pension medical funds in the public service like GPF and GEMS, or even a transit, for example. We think it might just simply make more sense there just to link them to that. Chair, so our proposal really is that under clause 24 2A and 3 that we just simply insert a qualification that, with regards to conditions of service, just simply say in consultation with organized labor, subject to any collective agreement. Again, this is often normally it's in other legislation. And we think, Chair, under subclause 24.4, we should rather just see how could we rather link it to the existing state medical and pension funds. Chair, with regards to the consultative forum, we think it makes sense. It's a progressive idea, and it does already have good precedents, for example, in Cape Town, where you have similar such forums, but it doesn't really specify who should be part of such a forum. And we appreciate you may not want to micromanage, but it would be useful to have some sort of broad indication of who should be constituted. We think perhaps you could just simply have some broad clause that simply say you should look at including persons from labor, from commuters, businesses, civil society, communities in other relevant government departments. So you give some sort of indication. And again, Chair, if you don't give some sort of guidance, then you can't hold them accountable later when they just simply appoint 5 friends. Chair, I think more worrying part is around the enforcement inspection, subclause 44.6, where it limits enforcement inspections to office hours during the week, unless authorized by the judge or magistrate. We think, Chair, that's a little bit of an unnecessary limitation on the inspector's ability to fulfill the duties, and it could inadvertently actually enable those who want to destroy incriminating evidence to do so. And again, Chair, just to say the obvious, that the railway lines are not, in safety matters, are not limited to office hours, Monday to Friday. They work on weekends, they work after hours, etc. And we think the inspector should not be limited in that regard. So we'll just simply propose in that instance that the subclause 44.6 just simply be deleted, and enforcement inspection should take place at any time as the need arises. Chair, then just 2 similar clauses around appeals. So subclause 54.1, it specifically denies employees of the regulator the right to appeal to the CEO. We're not sure what is the rationale for it, but we do feel it's an unfair infringement upon such workers' rights. The bill doesn't speak to any other recourse for workers. So we'll simply propose subclause 54.1 that prohibits or makes reference to employees being prohibited from these appeals, that should just simply be removed. And then similarly with regards to the board's appeal committee, it specifically speaks to that employees of the regulator don't have the right to make any appeals. We're not sure what is the rationale, what is the harm they're trying to prevent. For us, it doesn't make sense. Why would you need to do so? And again, we'd simply propose that subclause 55.1 that we remove that reference to employees. Then, Chair, maybe just 2 kind of broader societal context issues. I think we all know the real crisis of railway safety. And in our engagement with the department, with provincial local government, and even the 2 rail entities, Metro Rail and Transit, we never can really get a clear straight answer about who exactly is responsible for safety of pedestrians, commuters at railway crossings or along railway lines. And there might be a very simple, obvious answer to it, but the bill is silent on it. And I think we've all seen the consequence of many times commuters are dying because railway crossings are not properly secured, they're not properly maintained. One can go, just go around Cape Town, you can see it. The lines next to Langa, there's no fencing. We've seen the terrible accident in Stellenbosch or East Rivier a couple of years ago when a taxi driver driving learners jumped the railway crossing. And those terrible deaths of these young kids. So, Chair, but when you engage these institutions, Transit, Metro Rail, provincial, local government, they all kick the can between each other. So we think, Chair, would be useful, and again, it might be a very obvious thing, but we think it would be useful to have some clarity on who is responsible for what. But the consequence, Chair, right now is that we're seeing people dying, and we're seeing right now railway lines and sidings and crossings are not being properly secured. So we do think would be helpful to insert some sort of clause just to delineate who is responsible, etc. And again, there might be already some agreement, then why shouldn't we just simply seek to elevate it into the law? Chair, I think we all know that, just getting to the end, the real crisis of copper cable theft. We've seen train accidents because the signal is not working, with people actually dying in Pretoria and other places. I think we've seen, especially in Cape Town, over 100 metro rails being destroyed by arson. And, you know, the experience of workers commuting on trains is not a good story. And again, many people are just simply choosing to opt out of railway lines. And of course, this has a huge impact on metro and transit themselves. We're not really seeing sufficient pace with regards to arresting people. Often you get reports from workers at Metro Rail, for example, about inside jobs, often that inside collusion, including security companies. We've spent billions of rands on what seems to us be very inefficient private security for the railway lines. And again, there's been questions about corruption with the security companies. The Minister of Police had made a commitment previously to re-establish a dedicated railway policing unit. We haven't seen progress. So our proposal here is that, look, this wouldn't go into the bill per se, but we thought it's still important to raise with honourable members, perhaps in the committee report for the 7th Parliament, that, you know, the committee should consider recommending that SAPS re-establish a dedicated railway policing unit, and that also in the medium term and short term, the Defence Force should be requested also to be deployed to support SAPS in securing some of the railway lines. So, Chair, in conclusion, we support the bill as a whole. We think it's progressive and is long overdue. We support its powers to empower the regulator and inspectors, but we are concerned about some of the above-mentioned clauses. We do hope that our proposals might assist the committee to further strengthen the bill and to really ensure it can be, the regulator at the end of the day can be fully empowered to enforce railway safety. But I think, Chair, that's it in a nutshell, and hopefully it didn't take too much time, and thanks for giving us space as always. Thanks, members.
Thanks, Tax, for putting the views of COSATU across on the railway safety bill, which clearly will help us in terms of our deliberations in moving forward. You definitely operated within the time that was set, so and we appreciate that. Let's then move forward, honorable members, and invite the Gautrain Management Agency. Gautrain Management Agency. Doc?
Yes, Chairperson. I've assigned the hosting rights.
Okay.
Mr. You see, Mr. Hubert Luvalo.
Luvalo, are you on the platform? Yes, I can see.
Good morning, Chairperson.
My name is Luvalo. Just work on your screen. We can't see you.
Sorry, Chairperson, to interrupt. No, that was my mistake. Our next presenter is the Gautrain Management Agency.
All right.
Good morning, Chair.
Thank you. Morning, Mr. Luvalo.
Am I audible?
Are you Mr. Luvalo?
No, I'm Terima Wai from the Gautrain Management Agency, Chair.
Oh, Gautrain Management Agency. No, thank you. The floor is yours.
We have been battling, Chair, with the connectivity.
Okay. Let's stand up.
Thank you, Chair, for the opportunity you have given us from the GMA. I am trying to share the presentation, and I'm hoping that it is going to be feasible for us. We have been battling since this morning with our network connectivity, and therefore I am trying to share the presentation. If I were to be given some few seconds, Chair.
No problem. Can you help Enrico or Doc? Can you help Mr. Luvalo?
Yes, Chairperson, the hosting rights has been assigned.
Or should they help you, Mr. Luvalo? Can they screen for you?
Hi, Chair. I think the current presentation is from the Gautrain Management Agency. Otherwise, on my side, I'm sorted for Mbombela Concession Company.
Okay.
Chair, I'm sharing the presentation. I'm hoping that is visible from your end. Let
Okay,
me know
good.
if it is appearing.
All right. No, it is appearing.
Is it appearing, Chair?
Yes.
Thank you, Chair, for the opportunity you have given us to present the comments from the Gauteng Management Agency. At the outset, Chair, let me appreciate the opportunity that have been given to us since 2018, when the bill was first drafted by the Department of Transport. We have traveled this journey with them, and they have incorporated most of our substantial comments that have been made on the bill throughout the entire legislative process. And we are quite grateful for the opportunity that has been given to us. And with the bill as it stands, Chair, together with the members of the Select Committee, we are grateful that indeed it will address some of the challenges that have been experienced in the past. We have had some very unpalatable experiences, unfortunately, with the railway safety regulator in particular, on the issue of the safety permits that have been there have been a number of skirmishes that we have had, to the extent that at some stage we even had to approach the previous Minister of Transport to get involved in some of the issues. In particular, Chair, we will have two stages of making our presentation. First, we'll deal with the general comments. And among others, we are grateful that there have been a number of proposed interventions which will help to regularize the issue of granting the safety permits. Section 7.1a and 14d in particular makes it imperative for the regulator to issue the safety permit in line with a process which is fair, equitable, transparent, efficient, and cost-effective. We had a very difficult situation, if I were to give the committee a snapshot of what we experienced, where in 2016, 2017, the Gautrain Rapid Rail Link System operator applied for a safety permit. Upon receipt of the application, the CEO of the Railway Safety Regulator issued an invoice to the safety operator, the Gautrain system operator. And the bill, or rather the invoice, was in millions. And we inquired as to what will be the rationale behind it. We were told that because at that stage, the Gautrain Management Agency, together with the operator, were in the process of acquiring new rolling stock. We were told that the safety management system that will be introduced with the new rolling stock will require that we pay for the new technology that will be used. But we argued that the current permit that we're applying for at that stage will not involve the new rolling stock, which was not yet in place. And eventually we refused to pay the amount that was included in that bill, which led to the CEO of the Railway Safety Regulator refusing to issue the safety permit. We were then obliged to approach the MEC for Roads and Transport together with the Minister of Transport. And a night before the expiry of the safety permit, we were still chasing the CO. And eventually, with the intervention of the Minister of Transport, it was issued to us. But subsequently, that process of acquiring new rolling stock was abandoned, which negated the need for us to even have been required to pay those millions of rands for the safety permit in respect of the new rolling stock, which was going to introduce a new safety management system that never took place. We eventually abandoned that process of acquiring new rolling stock because the numbers on the Gauteng system were dwindling. And that actually reaffirmed our standpoint then that we were not obliged to pay any capricious amount that was included in the invoice that was issued. And that's the reason why we are quite grateful that these new interventions are coming on board, where the regulator will be obliged to act reasonably in approving those safety permits, and that in the event of them failing to respond within a period of 30 days, we could still continue to operate the Gauteng system or any other system for that matter, if indeed there is no response, and that any conditions that are being added to the safety permit should be reasonable. That certainly is a welcome intervention that we are looking forward to embracing, and that it will help in ensuring that there is no element of unreasonableness or capricious conduct on the part of the regulator as and when they have to issue the permits. I will then proceed, Chair, to deal with the specific comments on the bill. There are very few and far between because we, as I've indicated, been intimately involved in this process, and some of the comments that you have made in the past have been incorporated in the current version of the bill. With regard to the specific comments, we have noted that our concerns in relation to the various definitions of network operator, train operator, and station operators have now been consolidated into one, which will then be an operator. It will then, to a greater extent, remove any uncertainty or confusion that was created by the various definitions that have been appearing in the previous version of this particular bill. This indeed is a welcome change to the current bill, where we are now dealing only with the operator, which will encapsulate all the other operators such that there is no confusion. Because, Chair, in the past, the concern was we, as the Gauteng Management Agency, acting on behalf of the provincial government of Gauteng, are not necessarily the operator, but the way in which various definitions were included, we were actually clubbed together with the operator per se, where there was no clarity or delineation of responsibilities between the operator and the owner of the train itself per se. The specific comments that we have are basically three, Chair. The first one relates to section 12.4, which relates to the need for either the chairperson or the deputy chairperson to be elected by members of the board in the event of any of them not being available to discharge their functions. We thought this is an anomaly of some sort, in the sense that the reason why you've got a deputy chairperson is primarily because in the absence of the chairperson, the deputy will hold the fort on behalf of the absent chairperson. But the way it has been phrased, this section creates the impression that even if the deputy chairperson is available, the committee will still be required to select among themselves, or rather elect among themselves, somebody to act as a chairperson, when in fact the reason for having a deputy chairperson is primarily because in the absence of the chairperson, the deputy will be responsible for presiding over such meetings. The word "or" is the one that is basically creating confusion. If it were to be remedied, it will require that the phrase, the position of chairperson or deputy chairperson be replaced with both the positions of chairperson and deputy chairperson become, such that it should be both of them not being available for the board to trigger the necessity for them to consider electing one of them to chair. Otherwise, as it stands, you will still have the deputy chair. Then this provision will kick in and the board will be required to then elect among themselves somebody to preside, which is a serious anomaly. We therefore recommend that the relevant provision be amended as indicated in our submission. The second comment, Chair, relates to the term of office and conditions of service of the board. The way clause 13.1.3.c has been couched creates an impression that the minister may require the members of the board to retire. In fact, the word used is that they must retire. And the challenge is that if they were to retire on an annual basis, they wouldn't be able to complete their term of office, which is couched in clause 13.1.a. Rather, it will be advisable to create an environment or to clarify rather as to the circumstances under which the minister may be required to rotate, because as it stands, it is not clear as to whether the intention is to rotate the members of the committee or to deal with the non-performing members of the board. And therefore, we recommend that it should be clearer as to whether or not the intention is to rotate the members of the board or to lay off a third of the poorly performing non-executive members. But even with that, there may still be challenges because there could be instances where there is no non-performing member, or rather the entire board is performing well. And in such instances, the minister's powers, as outlined here, may be to a greater extent limited, or the minister could probably not be able to perform any power here in terms of rotating the members of the committee. Or there could be another scenario where all the board members are performing so well that there is no way in which the minister could have an entitlement to appoint new members on a rotational basis. The last comment, Chair, is in relation to the delegation by the board to either the CEO or another employee of the regulator, senior employee of the regulator. This is catered for in clause 20.1. The way in which this has been done will probably render the general intention of this particular provision somewhat ineffectual, in the sense that it provides that the board may delegate without taking into account the fact that the reason why you are having this multidisciplinary board is such that there will be some richness in decision-making where the diverse expertise will be utilized in the composition of the board, such that the decisions that are being made are not in any way being affected detrimentally by one person who has been given some powers or to whom the powers have been delegated without the benefit of the multidisciplinary expertise of the full board. In addition, we believe it will be advisable to have the parameters within which the board may delegate its powers, such that it wouldn't create an impression that only an individual has reached some far-reaching decisions without the benefit of being guided by fellow board members. in most of the acts of parliament, the board is precluded from delegating some of the powers. For instance, the power to create or establish some board committees. You'll want to have a situation where the board does not have the prerogative to even delegate the powers or functions that under normal circumstances shouldn't be delegated but should be performed by the board itself. Notwithstanding the comments that are highlighted in here, Chair, our conclusion is that if our comments were to be taken into account, they will certainly create some certainty and they will enhance the efficacy of the bill itself. But nonetheless, as the GMA, we are comfortable with the current bill as it stands, save for the few comments that we have made in relation to those three provisions that have been highlighted. Chair, let me thank you, and I'm hoping that I've stayed within the allocated time frame. Thank you.
Thank you for the opportunity that you took to present on behalf of the GMA. It makes our work also more common, more easier in terms of appreciating the complexities of this industry. And we really appreciate the effort that you took and your gesture to honor our invite. Having said that, I will now invite the Bombela Concession Company.
Yes, thank you, Chair. This is Hubert Luvalo. I will be co-presenting with Mr. Hannes Skippers. I would like to share my screen. Seemingly, there's a problem, host disabled participant screen sharing. Can you assist the chair?
Doc?
Sorry, yes, Chief.
Mr. Luvalo is disabled to share. Can you help him? It looks like
There we go.
Thank you.
over to you.
All right, thank you so much. Let me see where it's there comes the problem.
Is it open?
No, it doesn't. Yeah, please. Okay, some little bit of a problem here. Let me see. Is my screen visible now?
We see many items on your screen. You might just go to the NCOP presentation and click it. I think then it will show.
You want to share this?
Yeah.
Where is it on your desktop?
Correct.
Where's your meeting?
So this one. Here's my meeting.
Are you in?
Yeah.
Let's just join the meeting.
Oh, I'm already in.
So is that one there?
Mm-hmm.
This is not your meeting, is it? Okay, so why is that?
Okay.
And is this your meeting?
Yes.
Right.
Mhm.
There's a share here somewhere. Can you see?
Yes, there at the bottom.
That's share.
Mhm.
And where's the screen that you're looking at? You want to see
It's
this
on my
one here?
dashboard.
That one there.
That's the correct one, yeah.
Share.
Yeah. Is it now visible,
There
Chair?
you are.
Oh, thank you so much. Apologies for the little glitch on that. Okay. As I've indicated, I will be co-sharing with Mr. Hannes Keppers. This is a quick overview of our presentation. In terms of the introduction, I'll just briefly give you an overview of us as the Gautrain concession company, Bombela Concession Company, which is a concession for the Gautrain operations, and then give you the overview of the project and then the further comments. So these are the only areas which we still have some comments that we would like to discuss a little bit further. Okay, so basically, as the Bombela Concession Company, we have commented on the draft bill. I think in the past, as well as at this time, we have submitted our written comments. And on this summary, we just want to give a quick overview in terms of our remaining comments, as well as how we have commented in terms of our submissions. So we have made comments with regards to the definition, in particular to the ones that relates to the operator. What we will also add on in terms of this presentation is the comment on paragraph E, and where we've also added our suggested wording for the consideration by the NCOP. And then on the safety permit, in terms of its definition, we have no comments on that. And then on the proposed new definition, which we had made a recommendation of in the previous submission, we have reviewed the inclusion of the paragraph A on the definition of the operator. And as a result of reading that, we are happy to withdraw our submission with regards to the proposed definition that we have submitted previously. And then on section 7, we're happy with the inclusion of the comments which were submitted in the past. So we have no comments with regards to that particular section. We will then have a presentation part of it with regards to section 30. And in particular on this one is on section 30, subsection 4B, which we will basically outline our request for consideration for indication of the party responsible for the payment of the services of an independent reviewer, should this be required as part of the safety permit application, as this is indicated in this particular section, but it's not clear in terms of those responsibilities. On section 31, we again will raise the issue with regards to the justifiable circumstances as required in this section, as it's still not very clear in terms of the rating on the latest bill. Section 39, which we've commented in the past, we're happy with the corrections or the additions that have been made on this section. We have no comments on that. Same as on section 44, which we don't have any comments as well. And then on this section, which is section 27, section 30, and section 66, our comments basically will also again be more with regards to our previous request for consideration of a possible guidance in terms of the increase on the annual safety permit fees, as the section actually not encapsulating enough information in terms of what is the guidance, with the exception that section 66 indicated that the minister will gazette the fees for the next financial year, but without any clear guidance as to what will guide that. Then moving on to the quick overview of the Bombela Concession Company. Bombela Concession Company, on the side, it's basically on the blue highlighted, is a private company that is contracted to the Gauteng provincial government for the design, building, operate, and maintenance of the Gautrain as it stands. So this is the current operational structure for the Mbombela Concession Company. So our comments basically relates more to this current structure, to the extent that within the constraints of what has been contracted to us with the design, the building, operating, and maintenance, there's also a component of financing, partially financing the Gautrain system, which again, when we were reading on the other parts of the bill, we could realize that there is a bit of a ambiguity in terms of how the concessionaire is viewed by the bill, but we'll also look at that specific area when we get to it. So in terms of our comments, we have again just made an outline in terms of our initial comments and what is the latest version and what is now the current views that we would like to bring across for the consideration by the committee. So when it comes to this network concession operator, as I've already indicated, that we have withdrawn, so we'll not spend any time on this particular slide. Moving on to the definition of the operator, this is where, again, I've already indicated earlier on to say that with regards only to paragraph E of this definition, which is included under the latest version. So what we have now on our review looked at specifically was the fact that the current wording, in our view, it still does not accommodate and limits the complex of the private sector participation model, and therefore we would like to make some recommendation on this particular paragraph, where again we're saying in terms of this paragraph E, if it could read as a person who, although not owning, financing, or controlling the relevant network, train, or station, and then with the deletion of that part, but then we say performs the functions of functions contemplated in A, B, and C, which is the network, train, and the station, on behalf of the other person who owns, finances, or controls such network, train, or station in respect of the relevant assets, infrastructure, or operations. In that way, we see that it will actually accommodate the complexities that basically are brought in by the concessionaire kind of an operational model. So whichever the way the concession that is set up, it will then be accommodated with all its complexities if it were to be considered to read in this format. Dana Fanis, you've got anything to add? Thank you. Okay. Then moving on to section 31, subsection 2. In this case, in terms of the current version, as is indicated, but Mbombela, we suggest the consideration of the specifications of what will constitute justifiable circumstances, as the wording in this section to us, in our view, is still a little bit vague, if that can actually be considered in terms of this review. And then on section 27B, section 32, and section 66, again, as I've already indicated earlier on, our request for consideration is that if the bill could make an indication in terms of the guidance for the setting up of the annual safety permit fees, which would help the companies to be able to plan properly in terms of the financial impact for their operations. So we've made some recommendations or possible examples in terms of the use of consumer price index as one of the guidance that maybe can be considered. This is basically one of our critical areas in terms of really looking at how we can improve on that particular section. Moving on to section 34B, our suggestion on this part, as we have read, and we're happy with the inclusion of even our previous concerns, is that when we're reading this section, in comparison to section 4.3, which is where any operator may apply to be exempted on the bill, it is clear with regards to who will be responsible for the payment of any review fees that may be required by the regulator. However, in terms of this particular section 30, when you, as an operator, you make an application and then the regulator indicates that there is a need for an independent review, it is not clear as to who will be responsible for such cost. So in our views, when we're trying to analyze this particular section, it makes it difficult for the operators to really anticipate when they are making any application as to what will be the overall cost and the implications of the whole application. So that's where then we really request a consideration of the similar wording as it has been done on section 4.3. That basically take us to the end of our presentation with regards to our oral submission, which again, it supplements what we have already submitted. And I think in overall, the bill itself, it's accepted by us as the concessionaire in principle. And again, we appreciate and thank the consideration of our previous comments as we have submitted since, I think, when we started to have some engagement on this bill. Thank you so much. Thank you, Chair.
Thank you, Carvalho, for taking us through the presentation. At this point in time, I would then I get a sense from the members as to whether there are any clarification questions that they would want to pose. Of course, appreciating the fact that the next response will be given by the department to both oral and written submissions. Let me just check from members whether there are any clarification questions that we would want to pose. I get a sense that members of Honorable Khai.
Thank you very much, Honorable Chairperson, and greetings to you and honorable members and our stakeholders. I don't know, Chair, if I have, maybe if they take off the presentation. I can't see myself.
Oh, yes.
I'm properly framed.
Good.
Can they
Can you help there, Doc? Or if the rights are still with Mr. Luvalo?
Let me just switch my camera off because I'm not sure if I'm properly framed. Okay.
I've removed the tree.
Great.
All right. No, thanks, Chair. Just on the concern, the engineering group, I just want to, because they're saying that a part of their responsibilities or roles or duties is that of investigations. I just want to find out as to what is, if there is any interaction in terms of their investigation and findings with the railway safety regulator. So that's one question. But also, perhaps this would be also a general question to all other stakeholders. The understanding of the difference of the role of the railway safety regulator vis-a-vis the issue of the security of the rail line and the responsibilities of the rail safety regulator and that of the operators, because I see some of the proposal tend to focus on the security aspect rather than safety. I know that there's a thin line between security and safety. You can't be safe if you're not secured. So there's that thin line, but I think the issue is the issue of a responsibility. Who is responsible for safety? Who is responsible for security? And also in terms of the issues of the accountability. Who's accountable for safety? Who's accountable for security? Whether there is no mixing of responsibility with regard to those two areas. So with regard to the Federation COSATU, I just wanted to check this issue of the representation, whether in terms of the section, I think if you go to section 15, that Comrade Parks is referring to, as to whether because my reading of it, he will correct me if my reading is wrong, that it says a person is disqualified from being appointed or remaining as a member.
Yeah, I'm going to ask you to talk to that first question from the concerned engineers. I'm going to bring you in on that one.
Mr. Kalat, can you mute, please? Mr. Kalat?
Okay.
Yes.
The disqualification from appointment as a board, then it further says, in respect of board member other than person contemplated in section 10(2)(c), 2(e), he or she. Now, when you go to 10(2)(ce), it specifies those people that would be members of the board, which could also be employees in my reading, the engineering with the rail environment, and the commerce, finance, legal, labor, and economic matters. So as to whether employees are not therefore, or labor not accommodated if they have these particular skills, even if they are employees. But also, even though I don't understand the rationale with regard to why excluding those that are covered by Section 8 of the Public Service Act of 1994. But my understanding that entities such as Transnet, PRASA, I think including even the rail safety regulator itself, are not themselves covered by the Public Service Act. And therefore those would be perhaps working with the engineering skills, with their understanding of a railway sector, are therefore not excluded because they are not covered by the Service Act. And then the other issue, I think, is got to do with the appeals. I think it's section 50, if I'm not mistaken, 54. Maybe if because I could clarify as to whether that area that covers the employee, aren't employees already covered by the health and safety legislation in terms of the how their safety and health is regulated? Is there any need, therefore, to have to appeal using this legislation other than the health and safety legislation for issues of appeal? Thank you very much. Okay, with regard to the Gautrain management, they talk about the issue of just that I don't have now the document in front of me because it's also on the same laptop that I'm using, but they talk about the reasonability issue. I don't know how I noticed that the department just said when they respond to that, it's noted. I don't know whether they are agreeing. I know that they have not yet presented, Chair, but I saw in the document that was shared with us that they tend to be just saying noted. I don't know whether that noted means the clauses that are raised by the Gautrain agreed to by the department. Maybe at some stage the department will be able to respond. What do they mean by saying they are that is noted? So that particular issue of reasonability, because if you just put that as a clause, I mean, there could be different interpretation. What is reasonable in my understanding may be different from what is reasonable from somebody else's interpretation. On the Bombela, their definition of the safety permit. First, they want the safety permit to be defined rather than because in the bill itself, it just says it means a permit contemplated in Section 30, but they want it to be defined clearly. Rather than referring it to another section, they want it to be defined in the definitions themselves. But then in their proposal, they want it to be defined as such that a license issued to a concession network operator, a network operator, train operator, or station operator, or any combination thereof to construct, operate, or maintain a railway operation. My question is that what is contained in Section 30? Aren't they satisfied with that? Because that Section 30 goes further to further explain the responsibilities for those who should then get the safety permits. Thank you very much, Chair. That's all for now.
Thank you, Honorable Khai, for raising those questions. Let me check as well whether there are any other members further that would want to raise some questions. Let me also just get some clarity-seeking questions, starting with the concerned engineers group. From their presentation is quite clear that is focusing on the railway safety, but also the railway safety throughout the asset lifecycle management, and captures it captures, among others, the centrality and importance of qualified persons that has to be appointed throughout this cycle, obviously in terms of the input that they make relates to the international standards covering the asset management. Probably to just from their side, is their view that currently there is a need to massify the qualified and trained person within the industry, or is the challenge that the standard is not being applied in the rail sector? But if they could also just indicate as to whether are they supporting the bill or not, because it's not quite clear in terms of their presentation. The second one relates to the Trade Management Agency. Of course, they are quite clear in terms of where they stand in relation to the bill. They fully support the bill, but they make a reflection in terms of Section 21 around the delegation that the board has, and also they also make a reflection in terms of what is their take in relation to what does not have to be delegated, but the question will probably be if the powers and functions that could be delegated was limited through the bill, what powers and functions, in their view, should the board not be allowed to delegate? Because I think in terms of we had their approach and view in terms of Section 21, which does allow the powers of delegation. So I think it will be important to get a sense from them in terms of their lived experience, what should not be allowed to be delegated. Then the issues around the second point relates to the Bombela concession. No, the third question mainly it will relate to the clarification in terms of powers and definition. I think that is the angle from where they come from. Of course, they also support the bill, but the question that I pose relates to Section 31(2) and subsection 3, because there it looks like they have an issue in relation to justifiable circumstances, which impose special conditions in addition to, and not inconsistent with, the safety permit conditions as contemplated in subsection 1. And they have an issue around the use of the word justifiable circumstances. Justifiable circumstances could probably relate to what is lawful, what is substantively and what is procedurally fair, and what is reasonable. So, because these are the requirements, obviously, that would always attract any decisions, whether it is administrative or not. So the question to Bombela is, don't they think that the requirements for a for a just administrative action. By its nature, it is lawful. By its nature, it is procedurally fair and substantively fair and reasonable, and that there will be rational connection between the decision taken and the facts at hand. Those are the questions that I also thought I must pose. Let me give over to the presenters just to respond. We will start in a sequence in which they presented. Let's start with the concerned engineers group. Mr. Kalat.
Thank you very much, Chair. My apologies for the interruption where I was conferring with my colleague. Finger trouble.
Yes.
Certainly, in terms of your first question, your question, do we support the bill? Certainly, we do support the bill. There is absolutely no doubt about that. And certainly the aspects that fellow presenters brought up around the safety of the infrastructure also is very, very close to our hearts. Whether that forms part of this bill or other bills is a moot point, but certainly we absolutely support those as well. The question was asked about our interaction with the rail safety regulator. No, individually as a group, we have not interacted with the rail safety regulator. I can't speak for all of my colleagues on the screen. I personally, in my working time, did not interact with the rail safety regulator, but my colleagues and others who made an input, we have participated and sometimes led accident investigations within Transnet. Equally analyzed 20 major accidents where the damages was over 50 million to determine the pattern of root causes and what could be done to address the root causes of these accidents, and also have prepared many guidelines on safety for the organization. On the classification, sorry, on the certification of systems, if I could just perhaps clarify that one, that where rolling stock and infrastructure has to be declared safe, the aspect of certification comes in for, and let me use the example of a new locomotive, which is built, imported, and it is taken out on its first test, and there are professional staff, people, engineers, who say this locomotive is now safe for operations. Equally, when a signaling system is installed and commissioned, the signaling engineer, finally responsible for that commissioning, signs the train register. I certify that the signaling system is safe for the passenger trains. Now, that is not an operational matter. That is a certification matter. And we believe that that certification of those safety critical elements for the railway need to be regulated in an appropriate form through appropriate professional expertise. I hope that addresses the questions that have been raised.
Thank you, Mr. Kalat, for the presentation and for response to the question. Like I indicated, what we'll then do, we'll then invite Comrade Matthew Parks.
No, thanks, Chair, and thanks to honourable members. I think we had basically three questions, Chair, if I'm right, from Honourable Khai. I think the one question about, let's say, the two ones dealing with proposals that we had raised or concerns we had raised on the bill itself. The one is around the disqualification from the board. So the kind of the mandating clause, I guess, so to speak, clause 10, it does provide for worker representation. So that's fantastic, and that that had been born out of discussion we had with the department, I think around 2016 or 2018. And I think a commitment in that regard as well from the previous minister and so forth. So it wasn't in the original bill, but I think in the National Assembly, I think there was, positive efforts, and it was then included there. So we're happy with clause 10. I think our concern, Chair, is that clause 15, D1 and 2, we think would then trump it in the regard that, or put significant limitations. In the regard that it says that if you're an employee of the public service, you can't be included. Or if you're employed and it says any other organ of state, you also can't be included. So, any other organ of state, Chair, can be quite a broad thing. It could mean the public service, it could mean the public sector, it could mean entities, it could even mean SOEs, it could mean local government, etc. So I'm not sure what is the rationale there, because at the same time, the bill does exclude those limitations for representatives of the executive authority, the departments, the ministers, etc., for obvious rational reasons. Because department, when they have a representative or the minister has a representative, they want that person to be accountable to them, not just somebody that have quite a bit of a distant relationship. And also they want that person to have significant levels of skills and availability, etc. So we have the same kind of rational motivation too, that ideally we wouldn't want to just grab, a retired worker somewhere. Relationship may not really have a structured relationship with them anymore because they're retired. And also you want someone who kind of feedback issues to workers on the shop floor, etc. But you really want people with expertise. And to be honest, we're going to get people with expertise, and they'll be excluded because of that clause, 15D1 and 2, especially 2, which says if you're an employee of the state or any organ of the state, it's a very broad thing. You're out. We're not sure what is the rationale for. We can't find what is the harm that would be if we just simply either remove that exclusion or we simply extended the exemption for the state reps to also include the labor reps. But I think, Chair, we're the same motivation as government. We want people who've got the expertise. Myself, I might not have the expertise, etc., but somebody from that sector we think does have it, and we think it's going to add value to the board's work. Then, Chair, just with regards to clauses 54 and 55, where it specifically in the preamble excludes employees from any appeals to CEOs and the board appeal committee, we're not sure what is the harm that the bill is trying to prevent. There might be a rational reason, but we're not sure what exactly is it. What is the harm of just simply not excluding employees in the regard? OSHA, the Honorable Member Khai raised the question of, is OSHA not sufficient? But I think OSHA would speak to you as an individual worker, you as individual employee, etc., and your occupational health and safety use. I don't think it is as broad and as inclusive as a railway safety. So again, Chair, I'm not sure. There could be a rational reason. Perhaps the department has it and we could be convinced. But I think from our thing, Chair, is that why are we excluding these workers from it? What is the harm we're trying to address there? But I think, Chair, the last questions from Honorable Khai, it pointed to our kind of contextual concerns. And, we're slightly opportunistic that we wanted, because we don't meet with this committee every day. We don't meet to discuss railway safety issues every day. So I thought it's important to raise some issues with honourable members. Some issues would find space correctly in the bill. Some issues would need to find space in the regulations. We can have further engagement with the department in that regard. Some issues we think might be simply useful to include in the committee report, like our call for railway safety police to be established, support from the Defence Force, etc. Some things here which might be useful even for the handover report to the 7th Parliament as well. These are kind of critical issues. But I think, we felt that, look, there's an important issue to raise, because the issue of safety on railway lines and railway sidings and crossings is not being addressed. It is a real problem. And the issues of broader security and safety on our railway lines not being addressed, etc. We're not sure the bill is strong in that regard, but we do appreciate that some issues will fall outside. Some issues law enforcement needs to deal with, some issues security companies need to deal with, and obviously some issues belong to the regulator and the inspectors, and others to the operators too, and some to local and provincial government. So some issues might need to be simply find favor in our policy. But I think, we're raising it. It might sound very simplistic to raise it, but when we've engaged with the departments, provincial, local government, and the entities of the SOEs themselves, you don't get a sense of clarity amongst even themselves exactly who exactly is responsible. And again, there may be a very rational response, but what we do know for a fact, Chair, is that people are dying as a consequence. And one doesn't need to go far away. One can simply drive 10 kilometers from Parliament. Let's go to Langa. You'll see the entire lines, the fence is long removed. You'll find people crossing in left, right, and center. Fine, that's individuals misbehaving. But I think we all know the tragic consequence of that taxi driver who jumped the railway crossings at Easter Refier about, I think it was 6 or 7 years ago. And I think it was about 18 or so learners were killed. But it pointed to that there was an absence of complete security and safety at the railway crossings. And there seemed to be a kicking of the can between who exactly is responsible, etc. And again, there may be a very rational explanation, but we don't really find clarity amongst government and even amongst the bill. So that's why we thought it is important to raise it, because I think ultimately, Chair, in conclusion, I think we all share the same objectives, whether it's government, whether it's Parliament across party lines, whether it's the entities, or ourselves as the traders. I think we all share the concerns, but we need to, obviously there's a problem, we need to try to address it, Chair. So hopefully that answers the questions, Chair. Apologies if I spoke a little bit too long. Thanks, Chair members.
Thank you, Comrade Parks, for the response. Let's then give over to the both Gauteng Management Agency and then followed by Bombela in that sequence. Over to you.
Thank you, Chair. Am I still audible?
Yeah, audible, Mr. Mahoi.
Thank you, Chair. I have basically one question as well as a comment from Honorable Gai, the one relating to reasonableness, which we have raised. In effect, probably the reason why the department has noted our comment is that we are not making any recommendation for change. We're basically welcoming the introduction of fairness as well as reasonableness in determining whether or not a safety permit has to be issued. And therefore, that could be the reason for the department noting our comment. We are purely welcoming that intervention without necessarily requesting that the bill be modified and or changed in any way. The second issue relates to the comment that has been made by the Honorable Chair in relation to delegation. The Chair wants to know what kind of powers and or functions could be off limits with regard to the issue of delegation by the board. In particular, Chair, we had in mind the concern that some of the powers relating to the establishment, for instance, of the board committee, under normal circumstances and from a corporate governance perspective, those powers and functions are not delegable. They should remain the prerogative of the board itself, including the tenure of that committee or the membership of that committee, as well as any related matters, including remuneration of the board committee members. I think that certainly shouldn't be subject to anyone outside the board itself having to exercise it. That will be, in a nutshell, Chair, the issues that have been raised which require input from the Gauteng Management Agency. Unless I'm permitted to deal with any question, Chair, you can remind me of it, then I'll deal with it. Thank you.
Thank you, Mr. Mahoi, for the response. Let's go to Daluvalo on behalf of Bombela.
Yes, thank you so much, Chair, for the questions that were posed. I think I've captured the two, which I will deal with. One is on the acceptance or not acceptance of the safety permit definition, and the other question relates to section 31, subsection 2. So I would like again to just reiterate our last comment with regards to the definition of the safety permit, that we have accepted that without any reservation. So that matter on our side is now being closed. Thank you for the consideration of our previous submissions. Then with regards to section 31.2, thank you, Chair, for your explanation or analysis of what justifiable circumstances would mean, as I believe it's what it states in law. And our submission was the fact that in the absence of a general guidance on the application of these justifiable circumstances, it could actually invoke some discussions or disagreements in how maybe the regulator would actually make use of that. That was basically our reasoning for making such a submission. But we are happy with your analysis, as you have actually indicated. We accept it. Thank you.
Thank you, Mr. Alvaro, for the response. Honorable members will now invite the department to respond to the issues that emanated from the presenters, our stakeholders, in their interaction with the invite that we made to them on the railway safety bill. Committee Secretary.
Chairperson.
Who's leading the department?
I didn't get the information, Chair. Maybe.
Let's then invite the railway safety regulator. Maybe he can help, and then he will also introduce the team.
Good morning, Honorable Chair, and to honorable members and those who made their submission to the committee. My name is Mwaku Nakaipia, Chair. I'm the DDG responsible for rail transport in the Department of Transport. I'll be leading the team in terms of providing our responses to the meeting. Just to say, with the team that we have in the meeting, we have Ms. Moluko Machaka, who's the project manager responsible for the bill. We have Advocate Werner Krill, who's working with us in terms of this bill. And we have colleagues from the Railway Safety Regulator who are connecting with us at one point. We have Ms. Vasha, who's the head of legal. And we have Koliswa Shiburi, we have Ulebogen, which are part of the team chair. I'll just request that we be allowed to share. We're saying the whole disabled department from sharing so that we can take the committee through the responses.
Thank you, Mr. Nawapia. Let's ask the.
Well, we'll be sharing from Moluko Machaka's screen.
Brilliant.
Allow us to do that.
Okay. Can you help, Doc?
I've just done so, Chair.
Thank you. Over to you.
Thanks, Honorable Chair, and for allowing us an opportunity. And firstly, let me thank the inputs that have been given from both concerned engineers, COSATU, GMA, and Bombela Concession Company, which for us are very progressive inputs based on the work that we have done together. And we have responded, Chair, with regard to the metrics that we have received from the committee, and we have really consolidated that. Maybe from the beginning to just say, as Honorable Khai has said, that there are instances where we note the comments that have been provided precisely because we really just note the comment in instance they don't need any other affection or changes onto the bill. They actually really agree in terms of the comment that we have put. Just that I'll then start with the general comments, inputs, and then respond by the department. And then when we go further in the document, we then get to the details in terms of really the various clauses that we are responding to. Just starting with Mr. Colbert, where there's an issue that is raised in terms of the infrastructure element of the rail infrastructure. How do we then make sure that it's safe and secured, where we must ensure safety of both passengers and animals. Obviously, they've been a legislative issue, and to extend that even specification around how long must we fence, we respond as such to then say, as part of our regulatory regime, Chair, we have the regulations that are regarding infrastructure or activity affecting safe railway operation, which were done in 2020. And obviously, the key purpose is to really provide for the management of railway reserves, which include those issues of fencing as such. So, and those are the regulations that even when this bill move forward, they'll have to continue in terms of the transnational arrangement finally be referenced better in terms of that particular bill. With regard to the concerned engineers groups, there is a mention of a specification that cover requirements for privately owned wagons and obviously the vehicles that runs within our network. And the bill provides obviously the responsibilities of what then becomes operators and even infrastructure managers in that particular regard. So the issue of the technical parameters are really prescribed somewhere in terms of obviously the standards. When we're saying, we believe if you look at clauses 36.3 and 213 in terms of that particular element, it is covered. Moving to those comments by the Western Cape panel of mobility, which they obviously explain whether it is unclear whether the CS has been converted. We just want to put it on record, Chair, and it becomes a requirement in terms of its government processes to submit a bill or any policy towards cabinet. You should have really, one of the requirements is that CS, and as the Department of Transport, we have done that through the approval processing. And just at a high level to then say, we know there is a relationship between safety and security. And we know that the bill itself talks about railway safe operation and how we ensure that amongst the role players, and the issue of security being a matter that in wholly it's a matter of the Department of Police. But we recognize as a sector that relationship. Hence, you will see that one, as part of even the board of the railway safety regulator, you have a representative of the Ministry of Police. But secondly, in fulfilling our requirements in terms of the legislation and producing the state of safety report, we ensure that the statistics that are then provided to determine that picture are shared between both the railway safety regulator and the police themselves in terms of that relationship. But going further, in terms of the security regulation and the safety management system, we therefore make sure that we provide that the operator has a responsibility of, in terms of the passenger and freight that is transported, to provide for a security plan, and that coordination is not about we done with that. I thought it's very important, Chair, Honorable Chair, to then raise this issue, because it then obviously cuts across as a theme across a number of those particular issues. But you will remember that an encompassing legislation policy, which is the white paper on national rail policy, then talks to all rail issues, including the safety and security issues, and therefore we make some policy pronouncement in that regard, and we'll be having a national rail bill, which will still come through to implement some of those policy provisions that we think we need to deal with that in that particular element, Chair. And obviously, that sees us on their recommendation, like I've said, we have already dealt with that. There is an identification of a railway safety regulator where the bill is intended to provide transitional arrangement in due course and to repeal the railway safety regulator. So the recommendation there is that the white paper that was promulgated provides for a directive of devolution of rail to municipalities and further facilitate the needs for a concession and facilitate private investment and railway economic development. Though we know that, Chair, because those are the policy thrust and the policy position that have been pronounced in the white paper, and there are various steps. If we look into the white paper itself, there are short-term intervention, medium-term intervention, and long-term intervention, and the ones mentioned here, they are part of the short intervention of the policy. Currently, the department is in the process of developing the devolution strategy as pronounced in the policy. We have finalized the private sector participation framework approved by a cabinet in December 2023. We then demonstrate how do we want to work with private sector participation to ensure that there is transparency in that particular element. And as the department, again, in the introduction of rail economic regulation and transport economic regulation in the sector, we have a bill which went through parliamentary process, which is the economic of transport economic regulation bill, which really talks to the economic regulatory principle in that regard, Chair. With regard to the bill making proposal to combat rail infrastructure and vandalism and acts of criminality, and I think it talks to the issue that I have already talked to then say we are focusing obviously on safety issues, and the operators are required to outline how they are going to deal with security issues within their environment. And like I said, the bill talks to how we then engage with the ministry to ensure that introduction of railway police is achieved, but at the same time, that this infrastructure in our long-term view, with learning lessons from our airport infrastructure, and they will be declared as national key points. And that's when clear collaboration with the Department of Police really becomes critical in terms of dealing with that. And there is key work that is happening in this instance, especially in terms of the National Logistics Crisis Committee that has been established by the President, where there is a collaboration between the private sector, the law enforcement entities, especially in terms of those key elements, and the discussion around the railway police, and having dedicated task team to be able to deal with these issues at an operational matter. I think they are there, and obviously the circumstances will dictate on how we then move with those particular issues. There is an issue of a need for a new bill as compared to amending of the National Railway Safety Act. Chair, we are saying when we started with the project, initially was really about the amendment, but in dealing deeper with dealing with the work, we realized the number of amendments that were going to be brought based on the policy thrust that we put in there, the railway safety gap analysis. It is critical that we have a new bill that really seeks to really make sure that the incorporation and it's real and clear. But what it becomes a key principle and the message that we want to put through is that the bill really, a new bill doesn't really disrupt the kind of existence one of the railway safety regulator and some of the rail safety regime or implementation dynamics in that regard. It affirms continuity, it affirms some of those, hence even in terms of transitional arrangement, we then talk to how we then transition within those particular issues, and we don't agree with the proposal that has been put in there. And obviously, the issue of the crime in the regular environment and how does responsible stakeholders talk to that. I think we have really talked key, even what then become the role of all the stakeholders, including both the operators and the railway safety regulator. And I think Honorable Khai, in the comments that were put to the colleagues who presented, was really how do we make sure that we just expose what becomes the role of the railway safety regulator, being really that overseeing, providing regulatory framework and regime, and operators implementing that in terms of their responsibility. And obviously, there is that recommendation, which I think we believe we don't agree with it because the bill talks to that. The issue of rail devolution, I've already talked to that chair, is addressed in the National Rail Bill, by the same time that which we are working on, but the railway safety strategy, the rail devolution strategy, which the Western Cape government, especially the Department of Mobility, and even the city itself, form a part of those engagements that we have had previously. There is a recommendation that we need to have a formal agreement between the national heads of Transnet, PRASA, SAP, and Metro Rail. We believe that will be progressive in terms of corporate governance. It must be prescribed because the bill doesn't present it to happen. But where we think we have a responsibility to engage with other areas of interest, we make sure that as the RSR, we have those agreements that we then form. On the safety requirement, it is recommended that obviously we deal with the issues of subs, and I think I've addressed that in terms of the overall arching issue that I've dealt with, including there is an issue around provision related to a person with disabilities, and we obviously, in terms of the recommendation, that the bill must be amended for more comprehensive explanation of primary, secondary, key stakeholders to deal with these issues, but especially to address the people. I mean, as the Department of Transport, in line with the transport regime, we obviously talks to an access and regime framework, which we have really prescribed to. And because it's a matter that we even take, we continuously do that and have engagement with our stakeholders across the board to make sure that we really continue to do that. And we need, for example, at practical level, we'll even be having some universal accessibility, and we ensure to even our operators in the implementation of the infrastructure element to make sure that they deal with that. And we believe that it is addressed in terms of the clause in the bill. On the risk assessment, the bill does not provide nor create the impression, obviously, that is created in that regard. On safety and security matters such as overcrowding, those are really aspects of the security plan. But we obviously know that to say you don't want to legislate that in that particular bill. The issue around lighting, we note obviously we can go to that detail of doing that, and obviously the issue of safety and security matters and communication capacity, we believe it's outside the scope of the bill. And then those are really the issues of safety or security, which we have really and then talked to. There is an issue where there is a Minister of Transport potential of the bill, where it is recommended that the bill amended to how ministers attempt to manage a situation where there's a liability and make fair determination, and obviously compromised by his oversight by both the regulator. I mean, the proposed bill confers the powers to the other staff to act independently, because an independent and a creature of statute. And obviously, the minister provide oversight in terms of the tools that are provided, including the performance agreement that is signed with the board. And obviously, when it arises, the executive can be able to then make sure that they do that. But obviously, clause 7.1.1a then deals with that particular element. I mean, the issue of discretionary powers, obviously, where there's a recommendation that it is recommended that the no power be conferred in the bill to be considered to ensure that the appropriate guidance of those powers is that. I don't think we obviously our position that we don't need to go into that particular detail and at a high level to then say the provisions are archaic, because this bill and obviously working with the state law advisors, it has really passed those elements of constitutional applicability. And we therefore obviously agree that there are those issues that one becomes legislative issues, but at a board level, there are governance issues that are dealt with, including the board charter, will then obviously operationalize some of this matter. Obviously, reference to Parliament, it is proposed that the bill be revised to refer to the Portfolio Committee responsible for any safety matters and obviously the general views. For us, we disagree because Parliament has its own rules in terms of the referral of any matter that are brought to them with regard to their competence. There is an issue around language and drafting errors to improve the text. The legislative drafter reviewed the bill using generally accepted Commonwealth talking practices, as well as in this support of the language. Our view is that the bill was certified by the state law advisor as meeting legal and requirements for drafting, supported by the parliamentary legal advisor who attended obviously the bill at the portfolio committee level. And where there were those issues, the bill has really dealt with those issues. And there's various elements of how do we draft, and as it is aligned to the draft state law advisor legislative drafting guide, we believe it really sent the message out there in terms of what we wanna deal with and what we wanna convey and legislate in the interest of public safety in the country. By concerned engineers group, there is a detailed element really of how do we deal with the issue of standards and obviously show the train operating companies are dealt with in terms of those standards, and I think our view is that this will be prescribed in terms of regulations, and obviously government in their element when regulations are therefore defined, there is a process that is dealt with in terms of public consultation. We publish and then we deal with that. There is an issue of an issue of the network statement, obviously that has been published by Transnet, and the interim rail regulator is really working on this consultation, which will be having consultation in various cities of the country. And obviously, we obviously note the concern from the inputs from the concerned engineers group, and then obviously we therefore they must even look out to the gazette that we have put out there for them to be able to participate in that process, because it is still ongoing. The issue of the Luxembourg protocol and that the RSR should provide guidance. Our understanding is that it is a competency of government in dealing with that, because as the Department of Transport, we have that element to make sure that the Luxembourg protocol, it is incorporated in terms of our legislation. Remember, Chair, that we were at the select committee to present it as a requirement because of the requirement of the Constitution. And obviously, we believe once that is done, we'll be able to ensure that we obviously run some awareness among the industry. But we have consulted with the industry across the board in dealing with that particular matter. With regard to the prime responsibility of the railway regulators, railway operators, the recommendation that's a pretty very recommend the of the in the environment recommend that will be aligned to the said comments. We believe there's nothing wrong in the preamble referring to the prime responsibility of the railway operators, and the commission is noted, but it's outside of the scope of the bill in terms of what we obviously need to deal with. There is an issue about concerning general group where where we are acknowledging safety is that the state embodied in all processes in terms of railway operation. Process should be designed with safety integrated into operation interface as part of our priority and not added as an afterthought. The balance of risk and safety should be managed. We believe we have done that in the bill. We don't agree with that because part of the SMS at a high level is really to deal with those issues, and where there is a relationship with other operators, there is an enforcement of interface agreement amongst the operators. There is a input by Mr. Van Kerke, where there is an issue around the elements of the rolling stock that is being brought in terms of the third-party access. How do you make sure in alignment to the principle we deal with that? We're saying obviously the rolling stock will have to meet that requirement regardless of whether they are sourced from other operators or traditionally. And obviously the railway safety regulator will provide a critical, will play a very critical role in the implementation of third-party access, and there is obviously work happening in that regard, because in all, any other operators who must operating on a rail network must apply for a permit, because they'll never be able to operate there. It's an offense to do that. So in an alignment that are evaluating the kind of technology they're able to deal with the risk and provide feedback with regard to that. With our colleagues from Gauteng Management Agency, we are aligned in terms of the work and the comments that they put, and we really know them. And I think they've demonstrated how this government is caring in terms of really making sure that they take consideration of those issues that are raised by stakeholders with regard to, one, the lessons that we have learned over the years, but some of those that are brought into our force. Moving to what was provided by COSATU, which where we appreciate COSATU welcoming the bill, and we've engaged previously in terms of this particular issue that they've raised sharply in terms of the issues. And I think our view is that in terms of the board issues, I think key is that, one, we want to have the board reflecting really the competencies of those particular issues. And I think even Honorable years has talked to those issues. We believe that in terms of the board, the board determines, like I said, the governance framework, including how the quarterly meetings, but there is a program obviously on how they deal with that. And I'm sure the issue might be how do you make sure that the board doesn't obviously overstep in terms of operations. But I believe as a shareholder, in terms of when there are circumstances, you would be able to deal with those particular issues. There were issues raised in terms of the issues of consultative forums. We are saying let's look at clause 28, obviously, because this is a forum that was requested by the stakeholders. We believe that all stakeholders in the sector, obviously union included, will form part of those forum, obviously aligned to the constitutional guideline principle in terms of how we deal with that. The issue of appeal of employees, we believe that the employees' appeal is governed by a labor legislation. But secondly, in terms of the safety safety legislation, health and safety legislation, I think we give that recognition in terms of the bill. But the appeals that we are providing is really where stakeholders told us previously that they have a challenge that when there is they have a problem with the decision of the CEO that has been supported by the board. How do they appeal beyond instead of running to the court? And I think the comments that was brought in by our colleagues from GMA address to those kind of circumstances of how do we then deal with the issue of transparency and obviously so we are really trying to provide that before we even get to the minister. And maybe obviously are responsible for safety and security oversight, obviously looking at the SMS becomes a critical element of how do you then deal with this issue. I think the issue of security I've already dealt with, even though it comes from COSATU. Obviously, I've dealt with in terms of infrastructure, the regulations, and the regulation deals with that together with the SANS standards. On the issue of deployment of SNDF, that was obviously provided by COSATU. Obviously, it's not really about the bill, but it's how, as government, both we working together with all law enforcement, how do we then make sure that we secure the rail infrastructure and making that deal. Getting into details of the clause by clause definition, Chair and honorable Chair and honorable members, obviously dealing with the definitions. We obviously there was one of the Republic which we don't want to re-legislate. It is there in the constitution of the country. And on the Bombela concession, the issue of the safety permits issue, comment not understood, but obviously with what was provided in the presentation, we believe that what we provided suffice. And then on the proposed definition, the definition of operator, they've acknowledged that it deals with that. On the private partnership, the definition is not used in the bill, therefore not accepted. There's an issue around the like to consider suggested simplified version and further decline, but obviously our definition of an operator obviously is able to deal with those to be able to, and I think this was really included based on us trying to obviously look at the concession element, because we have actually learned from that and have really introduced some of the dynamics when we are trying to deal with those. There is a suggestion that obviously on the definition of the network operator, we are saying our subject that both network operators are therefore defined in terms of Western Cape. Department of Mobility commented that this be extended to the person with short-term impairment, reflection, definition, obviously then with other legislation, and we know there's a critics of how we then work together in terms of that. Obviously, in terms of Mr. Kwadonike, not agriculture will not be able to obviously be applying this environment. All of our have to standards will be determined by the minister with the implementation by the railway safety regulator. I've dealt with the issue of those definitions. Moving to clause 3 in terms of the object of the bill. Obviously, the issue of assisting in the educating the public and safety and the risk associated with this. We therefore refer to clause 7.1.g, but to then say with the work that the regulator does as part of their work, and obviously learning from some of the incidents that have happened in the industry. And Mr. Matthew Parks talks to, for example, the Cape Town incident of the driver who passed the red signal, and obviously those particular challenges, including the Rustenburg, one of those. So we have really actually been running this rail safety awareness campaign, which we really do in various parts of the country as part of the operational mandate, and some have been even included as part of the strategic plan of the rail safety regulator over the years in terms of how we then operationalize some of this of these issues. In terms of the recommendation that the new paragraph be inserted to state that ensure safety of rail passengers through the deployment of security key, whatever. I've already talked to those particular issues to then say it's already included in paragraph. As a text in the bill is reflected. Deployment of security is not another sub-function, but the aspect of security obvious in terms of that security plan and how it's incorporated in terms of chapter 4 of the safety management system. It becomes a critical element. Moving to the issue of exemption, which is in clause 4.1. Obviously, we have included that to then say, and I think we believe that we have included a clear criteria, and obviously the reasons for requesting exemption cannot be limited. The clause needs to be flexible so that we obviously deal with our non-development. It then becomes the prerogative of those who are charged with this responsibility to be able to then guide and to do that. And obviously that will then be prescribed as part of the regulations. With regard to how do we deal with a minister to publish the application for comment in the Government Gazette, the applicant to respond to comment received on the application, obviously to change the word may to must. Our view that flexibility is required, as well as requests for exemption do not need comments, and then can be published on the website. The minister obviously to exercise those powers, and we know the cost in that regard can be very exorbitant, and we don't obviously those that brought the application might be able to cater for those issues. On the issue of transparency and what the minister will have to take in terms of how to deal with those as a special exemption, whether it's been abused or whatever. I think for us, we don't want to prescribe is that the issue of good grounds has been interpreted judicially and it's not too vague, and we believe that it can be able to deal the cause and obviously apply itself in terms of those circumstances. We're moving to clause 7, which talks to the issue of really operational capacity and those elements, which really talks to how does operators, one, demonstrate their capability of running railways, and how, because they are responsible in their SMS of how they're going to ensure safety in their operations. For us, we believe that is enough, but obviously that's not the mandate of the others. But obviously, how we provide for reporting is provided in terms of the clause 6A, 7.1, B, 7.1, F, 8.3, 13.3B, 23.2B, and obviously C, 23, 3, 29, 28, 38.8, 51.4, and 5, and obviously and 7. And obviously, for us, it's operational capacity. I think is then dealt with that in that regard. Concerns obviously by clause 7.1, we see a number of comments under that clause 7 by both Bombela Construction Company, Western Cape Department of Mobility, and obviously Concern Engineers Group, and we will be able to deal with those. Obviously, the first one says unclear why the was necessary were inserted. The regulator should be required to provide the information and advice from time to time, and not agreed that the general information preferred may not always be present or obviously and not relevant. The consultation, in consulting the operators, with this word will be the operators could veto anything in this regard, and obviously not agreed, because the responsibility of oversight then becomes that of the regulator. The issue of advice and the minister's action or condition or trend in the environment. Standards is an important monitoring tool, obviously required from standards, and I think that's what we do when we develop our legislation and regulation. We define a problem, we do some benchmarking both with other industries, and obviously, or whether we do it internationally. To keep abreast with international rail trends on rail incidents, to evaluate and advise on those. This is subclause 1F, but like I said, we already dealing with those particular issues. In terms of concern groups, concern engineers group, my apologies. There is some element put there in terms of the objects of the legislation, and obviously the issues that have been raised, they have been covered in terms of chapter 4, chapter 6, and then obviously clauses 46 and 47 of the bill. The board of the regulator clause 9 Western Cape government to then say we delete the weight as far as possible, removing this weight to the exposure as elements points not to the net, which will be detrimental on the foundations. The second element, even how do we then elaborate on applicable standard, the issue that RSR, one of its mandates, will develop the standard, which will change over time, and the general clause is sufficient in that regard. The recommendation that the temporary government will be changed, the rail safety regulator incorrect, rail safety excludes commuters and other users. So therefore, the phrase sector is broad and encompassing in terms of our submission. The issue of the composition of the board, which obviously there's various elements provided by both COSATU, Western Cape Government, Department of Mobility, in terms of clause 10. We obviously have addressed the issue, previously saying the aim is to obviously have the boards at a high level, and if those members for example, we have experience in labor and they're being involved, the competency is really what we deal with regard to that. With regard to the recommendation that the clause be amended, we've already dealt with the issue of the mandate of the Department of Police and its responsibility in terms of how we then collaborate on the safety elements. A further add on clause 10, listing each of the field in terms of CBAR program, we believe is incorrect. As board members who collectively have actively demonstrate and in terms of how do they run the affairs of the regulator. And looking to the clause 10.2, obviously the recommendation is that representative of the Department of Public Affairs be included on the board of the regulator. We don't agree as such. Why? Because obviously in the board, I mean, a general principle is that on the board of a regulator, you would want to probably provide for the operators themselves, and obviously how do we deal with the issue of conflict of interest in terms of the shareholding ministry in that particular regard. The clause 10.4, as only executive member of the board is the CEO, which makes the majority of the the comment that the clause be declared what needs to be granted. And we believe that, and our subject is incorrect, especially that only 7 members of the board can also have executive members. Some of the assistant members could be appointed to executive position. This approach does not have a negative impact in our submission. Clause 11.3, we in terms of the recommendation, that the clause, amended clause, that is clear that the minister has a choice to appoint personal guardian and not as obligated to appoint them. Incorrect interpretation is the intention that the minister is obliged to appoint as, from obviously the nomination list based on the process that we then run. On the Western Cape, again, which is the recommend that the will be revised to make clear that the intention of the provision obviously refer to the waiting clause 11.5, which is clearer, similar to that. We believe that subclause 4 speaks to the general appointment process, whereas subclause 5 deals with individual appointments, which may be the whole body is the appointment of obviously critical of the appointment of the board members. The recommendation that it is unclear whether the intention up to the state that the chairman of the chairman may only be chosen from non-executive board member. The dealing is to say that then the wording should really be revised by the state. Consider wording to revise the dealing. Then for us, one, it is not clear, but obvious in terms of the government, the governance frameworks that the board develops to be able to deal with their business. One, including the board charter and amongst others, they will be able to prescribe those particular operational elements. Recommendation on the issue of clause 12.4 A, where there is a suggestion that we consider the use with vacant with regard to clause 12.4. And we submit that vacant means an absence of equipment, and the reason for absence for us is irrelevant. The ones to the position being vacant, not to a person, as the comment indicates, it means that no person has been appointed to positions listed in that regard. Clause 12.5, a recommendation, and that obviously a notice for a period for the chairperson to vacate his or office is not included. The agreement that the specific notice of period being considered for us, we believe is impractical because circumstances might warrant whether those people then make it within 24 hours or any. So acceptable means in that regard will be able to be dealt with in terms of the practicality. Moving to clause 13.1, 13 which is at a high level with the term of office on the conditions, but zooming into 13.1C, where the recommendation is that the clause be rephrased so that its objective is clear, whether or not it's informed by the need to regularly rotate board members to enable the minister to lay off one poor non-executive members obviously subjected to the challenge could be when non-performing members are less than 1/3 of that. I mean, our submission is that the way it must prevent the impression of voluntary process, the phrase is that a greater number may be involved depending on that. I mean, we obviously the whole board at one point and the continuity ensure that the performance process will be the matter of community. And we know that obviously in line with the government principles is that an annual general meeting in line with the government's requirement, minister is able to then confirm directors in terms of that. And those that have served and served well, they'll be able to continue in line with the provision of how many terms they can be able to serve. With regard to clause 13.1D, where review the internal meaning of the executive and non-executive of the board and ensure that it is reflected throughout the bill. We believe that it's unnecessary. The members in clause 10.2C could be seconded to serve as the two members of the board in that regard. Obviously, the issue of security in clause 14, I've dealt with that previously. That is the mandate, but the relationship, not the mandate of that, the relationship that we have talked to. Moving to clause 15D, I and D, figure 1 and 2, obviously, there's this issue of really how do we deny representation of the board that will include individual exercise. I think for us, when we do that, we will be able to make sure that even those that are required in terms of what the legislation provides to have this kind of representative. You can just imagine when you have we are dealing obviously with an operator and a member of that operator, or in brief, that operator is part of particular body determining either the condition of the permit or whether an element that has happened in terms of the certain signature, in terms of the operators themselves. So we believe, I think, that we will be able to do that. And we believe we are managing because even where organized labor has really made people forward, is those that are outside the ambit, but obviously are able to discharge the responsibility in that regard. In terms of clause 15F, the regulator may direct the reporters in a course of action that involves the procurement of goods and services, and the decision is to avoid any conflict of interest. For us, it's really not agreed in practical. That's really not the space where the regulator plays. The issue of clause 15F coming from the Western Cape Department of Mobility, elaborate the meaning of the term immediate family member, and it could be inserted with the wording that could start with the following, and for the purpose of this. Not agreed echoes similar provision, obviously, in other legislation, but we don't really legislate. Moving to clause 16, zooming to 16.3, the issue of termination, replacing the word the termination incorrect, making specific reference. That's our submission. Clause 17, which is meetings of the board. I think we have dealt with it previously too. I think for us, the issue of flexibility, it is required that we must be able to deal with that, obviously, not being abused, but that covered in terms of the governance framework, and the charter be one of the issues. And obviously, there is an issue that has been raised there to that the minister and the board will still have the little recourse on the bill, because at the same time, the board has a critical role to play against the context of large scale third vandalism and assessment, and obviously with the operator. For us, our bill that whether it's the board of the regulator, our submission is that the board of the regulator or the operator, board members in their nature have particular duties which make them accountable. And I think the PFMA is very clear in terms of their responsibility, and it makes them accounting authority of those in terms of that. And we know when that doesn't happen, they can be taken to task as delinquent directors that have not been really discharged their work. Looking at the responsibility, looking at clause 17.3, the issue of formal traceable communication dealt within the general comments even above, we don't agree in that specific clause. And then on the issue of competency in terms of the gap analysis, see clause 10, which really address those elements. Clause 17.10, after decision taken by the board, may request his objection decision to be recorded. The person must submit the statement to the minister. Obviously, will represent the facility transparency. Our submission is that it's inherent in board meetings and rights to be able, obviously, to deal with that, make sure that the guidelines and the other operational element of that are adhered to. Committees of the board, clause 18, zooming directly to clause 18, 1B, in terms of the metrics. Obviously, the issue is really appropriate person, which is unclear. Our submission is that C clause 1 to interpret appropriate person means obviously relevant people in that regard. Clause 20, submission by GMA. Obviously, our element is that our submission is that when you talk about the delegation element and the criteria, at the end of it all, the Railway Safety Regulator Board become the accounting authority in terms of applicable legislation, including the PFMA. And the board itself, in its governance framework, must be able to develop a delegation of authority that guides that, which obviously will differ in terms of circumstances in itself. And we believe that the board will obviously deal with that parameter in that particular element. And because they are the accounting authority, they are not absolved from any accountability in terms of decisions that happen in that element. So that really becomes our submission with regard. On clause 21 of the dissolution of the board, that there is a recommendation on this oversight role in Parliament, and obviously the recommendation is proposed that such oversight role should also play the position of the board, but the minister proposed subclause being inserted to promote for the minister to inform Parliament when then to resolve the problem. Obviously, say look at clause 21.2, the practicality element, as the Parliament is not always in session when some of these matters of national interest sometimes are obviously taken with that. Clause 21.3, which talks to the issue of unclear who may be appointed an administrator. Obviously, clarify that we believe we should be flexible, and that's our submission, and the minister might be able to apply with this discretion doing, and at that particular time, what are the interventions that are needed to be able to steer back and the railway safety regulator. Clause 21, 1E, the condition of asset safety record have deteriorated beyond the international norm. They should assume contemplate about the model FM due to the condition of asset and safety record of a railway are monitored by the monitored, and obviously that is done in terms of the regulatory tools that exist in that regard. On clause 22 of the chief executive officer, zooming to clause 22 2, with a recommendation to obviously amend the clause to provide for assignment to maintain conditions of the CEO to the board and its committee. We say not agree the board can at any time offer advice to the minister. See clause 1, 7.1 and E in that regard, and this is a general power to appoint the committee in terms of the committees of the board. The clause 22.4, which then talks to the phrase due process of law is vague, delete due process as stipulated. We believe is not vague, already provided for legislation in court rules and employment. Law applies with regard to that. And addressing the issue of incompetence on clause 22.4 over the period, and obviously that misconduct due to incompetency, and that will be dealt as such. Clause 23, functions of the CEO, and obviously going to the sub clauses there, zooming into 23, 5A, which is a recommendation to then say the qualification that the acting CEO should be an employee of the job removed, as it should allow flexibility to appoint. We believe obviously is impractical without the person requires immediate action, and independent of the other side, the interim measure. I think for me, it's important, and that doesn't exclude the shareholder to still appoint the accounting authority to still appoint obviously how to deal with that particular issues. Submission by COSATU, clause 24, 2A and 3. I've dealt with that previously. Obviously, how do we deal with collective bargaining? For me, the staff of the regulator obviously are covered in terms of labor law, but we know at an operational level through the operators themselves, there is a bargaining council that operates in that. Clause 23, 8, obviously I've dealt with the issue of obviously how do we make sure that the CEO submit the document and policy, including the procurement document. Our submission is that obviously procurement is included in that, all those strategic documents that are included that are determined one by the board. And secondly, say on the same clause, the detail of the document be stipulated. Obviously for us is impractical. Flexibility requires document change over time, and obviously we don't have the luxury to go and amend the legislation at that particular. So in clause that really able to do those and handle it is important. And moving to clause 24 on the staff of the regulator, where it has been raised on the obvious condition and remuneration, we refer to clause 23.4 of the bill. 24, clause 24.5, in terms of how do you maintain control of the wage bill and reward excellence, we refer to clause 24.3 again of the bill. On the issue of liability, which the comments cut across in terms of both submission both by concerning fitness group and the Western Cape. Our view and submission is that good faith in the standard and statutory terminology and the truth cross and obviously there is a provision which can be found in many acts of parliament. And the principle is fully embedded in the State Liability Act, which obviously provides for that. And obviously, how do we not legit? And I would believe the comments do not take account of many court judgment in this regard, which we have aligned in the bill, which is our submission. Clause 27 on the funds of the regulator. Bombela suggests that inclusion of guarantee or annual safety permit fees will be determined, and obviously the manner in which is not specified. Annual increases should be reasonable to get. I mean, we sympathize, Honorable Chair, with the Bombela Consulting Company and GMM on the previous unfortunate experience they've gone through, but that for us must not be bring us to how we deal with the legislation in December. We have dealt with that. I mean, there is a clear process. Obviously, if you look at section the clause that deals with the determination 1 of the safety permit and how it is dealt with, and annually as a practice in line and obviously provided by the legislation, there is a process we run which is consultative of determining the safety permit fee. We start with the safety permit fee model, and then after the model, we do determination annually, which we publish in the Government Gazette for 30 days for comment, and obviously we're able to even respond to that. So we believe there is a transparent way of how do we deal with that particular issue. And I think how we have dealt with that, you will see in the bill itself, the duration of the permit goes beyond 1 year. The determination of fees really does provide for the work that we then do. Moving to clause 29 in terms of reporting to the Minister and Parliament, zooming to clause 29 1C and 29 1D. We believe it's already the condition of asset storage I have talked to already provided for in under number clause 21D, and then we move to the issue of safety permits, clause 30. 4D, where it is recommended that the application be published in the Government Gazette, to local newspapers, any other local media with the regular consider appropriate. We believe this involves delays in additional cost and does not attract general public direct. We've been doing that in the Gazette over the years, and I think we've not really had challenges. And in addition to this, after we Gazette, we normally have a database of our permit holders, and we obviously make sure that we reach out to that. Clause 31, the Bombela submission. Obviously, we believe this will exclude the concessionaire, which is unacceptable. We are doing this to be able to make sure that third-party access and participation is a principle of the white paper of the policy. It is obviously covered in this regard. Zooming to clause 34B, the suggestion that the examiner upon any application contemplated in section 1, taking the required applicant subject to cost-independent review, be conducted of the information evaluation samples. I think for us that even application supplies an insufficient data, it must pay for the additional information. Any person might take a decision on review. The review may be as a review sufficient in the accurate submission. But I think for us, what we have done now in the bill, we now clarify those in those circumstances and the processes. And I think in addition to that, you then have the permit regulations, safety permit regulation, with them talks to those elements. Clause when you talk to 35, that the Bombela consultation is vehicle regards to termination of safety guarantee period. I think we obviously dealt with that. We'll say the different circumstances will demand different periods over time. Similar to the outcomes of safety management assessment and the risk of level, which I think it will happen within the period that we have provided on the period of the permit fee validity. Clause 21 on the conditions, Bombela suggests that include after consultation with the affected network operator, the circumstance, our submission is that the commitment accepted will only be done in justifiable circumstances as stated in clause 31.2 of the bill. Clause 31.2, Bombela suggests consideration consider specific of what would constitute justifiable, and I think we have already dealt with that in terms of that. And like we believe that an administrative decision must be just, and obviously RSR will deal with that in that particular spirit. The concern clause 31.2e, clause 31 2f, clause 31 2g, we believe those are really policy choice elements that when you deal with standards, you'll be able to then incorporate those. And moving to clause 31.3b, with the recommendation to consider the statement to revise the special condition could be applied to operators that this condition are unique to an operator, provided are likely to have negative impact on the operator. This is the condition could apply to permits. Our submission is that such condition will be added to the permit issued by other operating necessary special condition over and above the general condition which are determined by the regulator applied. And obviously, RSR will also consider other affected parties. They will apply that's a very unique circumstances, and we deal with that in that. On amendment of condition of the safety permit, looking at clause 2F, where there's a recommendation that clauses where initial decision-making body has not been identified in laboratory when necessary, ensure that appeal authorities' bodies are not conflicted. Already addressed in the current clause, no longer making reference to the board. The regulator may amend any condition. These are day-to-day operations appeal and addressed in chapter 8 of the bill. Zooming to the clause 32.5, obviously, we recommend to include clauses on the process that permit law should follow in applying for amendment, safety, and reference to the decision that are. I think I've already said that we have regulations that determines the process of application, and obviously an operational level. There is a permit fee guideline, a safety permit guideline, which is followed, and obviously that is even workshopped with the operators as an operational matter. Clause 33.2 on the surrender suspension revision of the safety permit. There is some recommendation, the comment there by colleagues from Bombela, where they propose that power to suspend and revoke sit with the CO, provided the CO's for approval to exercise an action, and given the extreme circumstances, such an action is preferable. I'm sure this comes from those unfortunate circumstances, but the key element is that obviously separating the powers that the regulator acts and the CO will decide a act on that. There's a clear appeal mechanisms and how do we then do that. Day-to-day operations, I think, are obviously dealt with by the CO, but following the appeal mechanisms provided in the bill, we can be able to deal with it. So going that on clause be revised to provide guarantee on the issues, and obviously the circumstances we say RSR probably in terms of the clause 33A, we have to provide for clarity. Moving to clause 3.6 is the word operation by law are necessary, and obviously for us we believe there is what we provided is therefore sufficient. Moving to clause 35, where there is a view that added to the clarity of the commission that attending institution, especially on the registration of training institution, we believe clause 32 35(2) provide that clarity. And furthermore, this is another matter that will be prescribed in terms of the regulations, and we'll be able to deal with that. And we believe that RSR is accountable and is a creature of statute, and the bill does not provide to that. They will consult, but ultimately they are a decision maker in that. Moving to the clause on 36 on the safety standards, rolling stock is a very important part of the. We know that that is agreed, and safety standards really deals with that. On the drafter could perhaps on clause 36 use of wording such as an issue as opposed to prescribe. Prescribe is correct in order to avoid the pending effect, and is really used consistent in terms of in the claim itself. Clause 32, 36(2), A, Honorable Chair, a recommendation obviously to explain the real environment. We have already dealt with that vis-a-vis that of the sector is constrained and obviously where it's used. 36(3), further identification of the standard will be the form of regulation that recommend that clause basis be clarified to state such. Regulation must be published. Standards are of high technical nature and often require explanation as to why particular standard is determined, which may not be obvious from the standard itself, but obviously evident. But if you look at clause 61 4 on the provision of provision, but at the same time, there is a process of how do you deal with various forms of regulations and deal with incorporation thereof. Clause 36(5), revised clarity meanings of both terms, which is one on each of the rest. The other term provide both specification and are defined that the recommendation obviously are addressed in that particular. Clause 36(6), person which looks at that we must add safety of person working. It's governed by the Health of Safety Act to provide clear distinction between the operation system and set aside working environment. Legislation already applies and no need to reference and re-legislate in that regard. On clause 37(1)(d), on the submission of the life cycle asset management, we have what we call ISO standard, and obviously that already provide in terms of various standards of that, because a life cycle, for example, asset management system is really the cornerstone of how do you then develop the regulatory instrument. Clause 38 on the consultative forum, which are dealt with in terms of the previous general comments, and obviously subclause 4 deals with that. Clause 38, 38(3), recommendation that the decision be provided in terms of matters that regulator may refer to the forum for consideration. For me, this is a consultative forum, and depending on priority and issue that I had that affect the rail safety at that particular time, we'll be able to deal with that. Moving to clause 38(6), or especially on the issue of provincial forums when necessary, is the declaration of forum itself, depending on circumstances, also provided in clause 38(6), already addressed reference to be only made to the consultative forum. Clause 39 on the railway safety information system, where there is the regulator must maintain national information system regarding the safety operations. The main aim is to prevent occurrences. We already have that in terms of the state of safety report that we obviously provide. 39(2), in terms of definition of the framework, see subclause 2C, and then on the determination of operation risk is covered under in that regard. And then we move to clause 39(3), is that where there is a proposal to include that the regulator in writing requires a permit and provide specific time or regular cases where level of information samples matters concerning Section 22 may be reasonably specified by the regulator, and the regulator may monitor the use of application in that regard. Document samples and details were submitted for that. We believe we have covered really the proposal. It's just a comment, no proposal in that regard to deal with. And the same that we note that comment, and then the way of state must be as communicate reasonable and relevant applies to that reasonable as suggested in clause 20, 39. In terms of clause 41 on the road safety inspectors, it is recommended that class amended to clarify this matter, especially with the lack of there are no specification and details as to whether the resident inspector will operate similar such as directed in their offices. We believe those are operational matters should be left to the RSR. The principle is that you have resident operators which at any element they'll be able to discharge their responsibility to ensure safety of railway operations. Clause 42 on the powers and duties of the road safety inspector, zooming into clause 42 where it might be useful to have a general protocol can then be applied to specific protocol to be completed by the operator. Inflexibility is required depending on circumstances. If our hormone operator, that's our submission. Clause 43, obviously, as indicated, obviously in bold, there is a number of suggestions not agreed due to obviously it's only provisional bodies to be able to do those things. So clause 43.1, where there's a recommendation that clause be revised to set out column, obviously because that ensure that there's a consistency with applicable case law and warranty. The current 43.1 has been amended to address the concern, and this clauses and all others have been considered by certified by the meeting all requirements in terms of the concern requirement and case law with that applicable standard. Moving to clause 44, should a recommendation that should be to ensure that there is consistency with applicable case law, such as and that we have this law and other have been considered and certified by the state. So we believe we fully meet the requirements, and that's our submission. Same with clause 44.1, it has been addressed. 44.3a, there is a suggestion that the railway inspector may, for the purpose of substitution or subject, enter and search any premises, and Bombela obviously provided it safe to do so. The issue is that our opinion that the safety inspector is obviously will have to use their discretion not to be dictated in how they implement that. The submission of clause 44.6, which one has even explained further by Mr. Matthew Parks in the meeting, obviously in terms of at what time do we then operate and all those kind of things that railways are. You'll see that what we then provide in the legislation is one, the first element is provided for normal routine inspection which happen within the office hours, but in unjustified circumstances, where the operator, the inspector is able to get a court warrant to be able to enter, and they'll enter that at any time of that particular accident. So it is immediately covered in terms of that element, and we believe that is aligned to those judgments that have happened over the zooming to 44 plus 44.9, where there is a recommendation that clause be revised in light of the comments, and obviously we believe police officers are trained to meet constitutional requirements, including here to ensure compliance. And clause 45.1 be revised. There is a recommendation that the clause be revised to make provision in which certain people may not identify as male or female. Self-identified is not a feasible factor, but the other people are not to be addressed in the bill. on 45(3)(a) and B, which are those clauses where there is a proposal that the bill in terms of confer the recipient the powers of the peace or by the criminal, if the recipient enjoys a similar piece of that means as per section of there is no justification why the bill obtained by also not given under oath and a recommendation that clause be deleted. Our submission is that clause 5045(3) does not provide for the format of a statement, but a person making the same may claim confidential to ensure that the information is protected when the inspectors report on the matter if the person claims confidence in terms of clause 5045(4)(c) of the bill. The risk of the railway safety inspector must consider then act accordingly. Moving to clause 47 in terms of the railway safety inspector dealing with unsafe condition, recommendation there that not be revised. What type of condition because the general meaning of that condition it's therefore we therefore submit in that regard. Moving to clause 47, one on the recommendation of the reasonable opportunity to be replaced with the minimum number of days that can be extended by the railway safety regulator. Flexibility required to them because reasonable differs between circumstances. Reasonable is often used occasionally in legislation as acceptably interpreted by court, prescribing it will nullify reasonable. And obviously, reasonability is not limited time periods in that regard. It's our submission. In clause 48 on the way, occurrence zooming to clause 48 2B, the submission there to that it is not clear what is meant by interest, which is indirect of being the corporate to that they will be clarified. That is referring to infrastructure, the indirect bearing on that. I mean, for us, that is not a requirement to tamper with the scene of the occurrence. I think that's our submission to the committee. Measure investigation recommendation that the wording to afford the minister the discretion to request the time because of the investor concerns circumstances. This should be in addition to the investor being afforded the discretion to submit the interim report as per clause 51 for submission. Our submission that this is correct. This is precisely there's no need or basis for the minister to request the interim report unless he or she included in that mandate of the investigator, which will be determined again in terms of the regulation to determine the requirements. And obviously, we're saying see clause 51 to F in that intent. Clause 52, 51, 2D, where there is a submission of to ensure wide audience is reached and the final report should be published in the government gazette, recommend that the clause be aligned with the provisional in the column to the left. I think for us a submission that cost and delays and operationally not effective. On clause 51(8) on the records, evidence, there is a very well and open. This might have obviously our view that is not accepted. The terms there must be an nexus between the request and the information in that regard to serve the particular purpose. The information containing the findings of the report may be conditionally classified and be not used as evidence in the as raised out. Like the same which investigation, aviation, United States, significant incident in other modes of transportation, the board seeks to ascertain that. So it's not agreed because the investigator must decide on the confidentiality aspect and normal legal rules of admissibility and confidentiality apply in that particular case. Move to clause 52 of the in terms of the submission. It's really around the issue of standard investigation where they must conduct an individual investigation are confusing while intended, that we believe we have obviously amended that to address the concern and under 52 form. On appeal to the CEO, the unusual treatment on terms of the workers' labor law provides for that situation is our submission under clause 54. Clause 55 on appeals to the board's committee. Honorable Chair, honorable members, there is a recommendation that there is obviously an issue where we must consider ensuring that the correct body is referred to. Obviously, I was subject that on clause 54, read without substitute provide for clarity to the Board Appeals Committee, CO, Board Appeals Committee, and the TAT, and that has been and that concern is really being done. The issue of really the workers' element, then in terms of the labor, and obviously bargaining council in those particular sectors in that. Section 55 on the issue of whether the appeal was not directed to the board applies to the committee, and why it has become there may not be any grounds of appeal. Resident General CEO replied to the ground appeal for the board to consider this. We consider the clause of amendment. And we're saying that has been dealt in terms of clause 55 and one we are already subclause 5 and clause 55 deals with the appeals of the board in entirety. And the moving to clause 55 where the recommendation is that the clause must be amended to show only a member of the board will be the chairperson and other 2 people of the appeals committee will be ordinary members. And the current 55.5 has been amended. Obviously, that deals with that. Obviously, it's chaired by a member of the board. On the regulations and notices, which is in clause 61, getting into clause 61(1)(a), where the phrase of any other place station might not be clear, the comment that will be amended to be a meaning clearer and further weight. Station should not be included. Any other place in addition to a facility of passenger to enter and exit a train, the station involved is obviously to be corrected. The clause on 61 4A, where recommendation to consider amending the clause to provide for electronic submission address not limited to physical address. We also refer to that email address included in that particular definition. Clause 61 5C, the issue of railway operations and railway operations which we have dealt with in the previously where to revise for the sake of time was in general meaning apply as such in terms of our submission. Clause 62 1 which talks to a recommendation to exclude the phrase and leave the design and construction of alternative railway operations. That design and construction typically refer to new operation while alternative typically refer to existing operation. Obviously, a suggestion in that regard, we therefore say new operation is necessary as may encompass aspect not covered by design and construction and alteration in that regard. We also need flexibility in terms of that regard in line with that, and safeguards have been provided. And look at clause 61 4 run together with 5. On the notice regarding the fees, where there's a recommendation that further requirements on consultation include additional transparency and accuracy in determining the fees. Therefore, recommend that the proposed fees be published for comment, and obviously be published for comment after determining the cost of regulating the factors should be weighed in the cost result of regulating. Further, a broad objective framework determine the payment. And we're saying see clause 61 4 and 5 consulting not take place in this process, but we are guided in terms of what applicable regulation talks to in that regard. Chair and honorable members, that's in a nutshell how we have really looked at the comments that were submitted and those that were presented, which will obviously added further clarity, and in some of the submission we have made, I was able to actually amplify in some of the submission that was submitted in that. With that, Honorable Chair, thank you very much. We'll hand over back to you.
Thank you, Mr. Makapia. for taking us through the responses of the various stakeholders. Indeed, it was a marathon. I want to check with the state law advisor. Your comment?
Good morning, Chairperson. Am I audible?
Yes, indeed, you are audible.
Good morning to everyone else attending. Thank you, Chair, for the opportunity. I'm just going to have a few responses. It's not going to be long, Chair, on some issues that may have touched on legality matters. Yeah, it may not go consequentially from the beginning because I made some notes, and as discussions went along, so I will start with the comments on clause 54 and 55 of the bill, Chair. Some of the stakeholders raised the issue regarding appeals, regarding the rationale around the exclusion of employees and suppliers from the appeal process. I thought I should just add a comment on that aspect, Chair. What I want to say is that employers and employees and contractual suppliers have particular internal relationships. So it will be inappropriate to include them in the appeal process. Certainly, they still retain their rights to approach the courts directly in terms of the Promotion of Administrative Justice Act. So they retain their right if there's any matter concerning grounds for review of decisions that the regulator would have taken. Yes, so there's a legal relationship, which is the one, the employer-employee, and with the suppliers, there's a legal relationship, which would be contractual. So those issues would be resolved, would be resolved in connection with that relationship between the regulator and those persons, Chair. So from our perspective, or our view, is that the clause is on board, and it is consistent with the Constitution, Chair. The other issue that was raised was with regards to the representation on the, not the representation, the exclusions, Chair, whether there's a rationale. One of the stakeholders raised the issue on rationale, and what I wanted to add there is regarding there are already representation from the state on the board, and to avoid over-representation of this from the state side, and also to make sure that the board is objective, Chair, those exclusions are included under those, under clause 15. So the rationale is to make sure that the board is objective, and to avoid bias, Chair, over the representation from the state side. That is just one aspect that can be added for those exclusions, Chair. I think the department mentioned others with regards to qualifications and experience in those. That's also the objective of the members, of the representation of members on the board, Chair. The other issue that was raised was concerning fencing, Chair. When we looked at the bill, when it was submitted to our office, fencing was included in the bill, but we had a discussion with the department at the time to say that this is a pre-constitutional bill, and the Constitution in Schedule 5 have included fencing as a exclusive provincial competence, Chair, to legislate. And it's under the municipal matters, Chair. So the only way how Parliament can legislate on this matter is if the provinces or the municipalities are unable to regulate fencing or provide for those matters, Chair. It's those intervention type of legislation. So, I mean, yes, there's concern from stakeholders that fencing is a problem. So if the national government can confirm that indeed it is a problem, then it can step in and then make legislation regarding fencing. But this is not an intervention legislation, Chair. This is a regulatory form of legislation. So fencing remain to be legislated on by provincial and local government, but certainly the regulator can implement and make sure that indeed operators comply with the standards set by the provinces for fencing, Chair. So who's responsible? It could possibly be both the regulator and then provincial and local government, Chair. Then sorry, my phone is just ringing like the temperature, Chair. The next issue, I think it's the last one that I'm going to raise, is regarding our drafting practices, Chair. I don't want to sound defensive, but we normally certify bills, and all of the bills that come through our office as to make sure that they comply with our South African drafting standards, Chair. But when we go through that process, there are various things that inform the steps that we go through to check that the legislation is on par with what we have set for ourselves in South Africa. But of course, when we look at sources, from various areas. Lots of academic writers write on the issue. It can be, there are specialists in drafting. So we incorporate those things in our system, Chair. And legislation is developmental. It's not stagnant. And therefore, we make sure that we stick to the standard that we have, but we're also open to incorporate new aspects of drafting, Chair. But always we apply the clear drafting standard that every reader can understand. So some of the comments that was made in these by the stakeholders was that certain words that we use may seem to be not clear, that the clear or the ordinary reader can understand, Chair. But normally when we have a piece of legislation, we write for the audience. So when we use the word acumen, it's a dictionary word, and it's something that would apply to people that would be professionals sitting on a board, Chair. And the understanding is that those members would, or those people applying would know what acumen means, Chair. So it's an ordinary word for people to which we are we are legislating towards. Just making an example, not to sound defensive, Chair. So the standard used in the bill, drafting standard, it is fully compliant with our drafting practice in South Africa, Chair. Let me just touch again on the issue of searches, which someone commented on regarding constitutionality. We have applied the case law on searches, warrant searches and warrantless searches, making sure that we distinguish clearly between enforcement, regulatory inspections, Chair. The case law is quite clear, and we made sure that we use those guidelines in those cases to make sure that we don't infringe on people's rights, Chair. That is why we excluded primary residences from searches, warrant searches, Chair. So those provisions are also on board. Thank you for the opportunity. That's all I wanted to say, Chair.
Thank you, Ms. Rudbaum, for the take. on the overall impression in terms of the responses given. I want to check, is Advocate Jenkins on the platform, Dr. Clark?
Chair, Advocate Jenkins had indicated that he has a conflicting commitment with another committee. So he's unfortunately not with us on the platform.
Okay. Yeah, no, I was informed. I did get the message. I thought probably might be done by now. Which then brings us to the point where we need to probably then agree that when we deal with the negotiating mandate from the provinces, we will just get an opportunity, we'll just give an opportunity to the parliamentary legal advisor just to make some reflection in terms of the comments made in relation to these issues. I will then probably give over to Honorable Khai.
No, thank you very much, Honorable Chairperson. It's just that we received the responses of the department very late yesterday. So we'll have time to study them and compare to the submissions made by the stakeholders. But there's just one issue that also the Office of the Chief State Law Advisor has responded on. Both on the issue of the composition of the board, as well as the disqualification from appointment as a board member. Particularly 15, I think 15, section 15 on the disqualification, the clause that deal with those that are employed in accordance with Section 8 of the Public Service Act of 1994. My question is that, because I noted the response of the department that this is not a representative board, but I mean, if you go to the composition of board 10, Section 10, 2B, already that gives an indication that it is a representative board, because B says not more than 9 persons representing civil society, including persons from railway industry, organized labor, or communities with experience and knowledge contemplated in section. But that indicates it is a representative board by virtue of having these sectors as part of the board. Therefore, my question to both the department chair for clarity and the representative of the Office of the Chief State Law Advisor, what happened in situation, because let's take, for example, the organized labor. The organized labor then decide that maybe some of the federations leaders themselves are employees. Some are employees of government. For example, COSATU is president and deputy. I'm not sure about the other leaders in the federation. Themselves are governed by this Public Service Act. And then because now the 10B or 10.2B allows for organized labor to be represented, what happened in that situation? Yeah, that will be my question, Chair, for clarity.
Thank you, Honorable Khai. Mr. Makaiba? Mr. Makaipia?
Yes, Chair.
The question from Honorable Khai?
Yes, Chair. I'll respond to that, Chair. For us, I mean, and maybe it's even in terms of practice, is that when we say you won't be, a member of the public service won't be able to be part of the body that you talk about that in terms of your normal application process. But if it's designated, like for example, you will have a member of the Department of Transport, because that's a shareholder representative, for example, it will be able to do that. And then even in the previously where you have organized labor being represented on the board, normally those representatives they then appoint are normally those who are not operationally involved in terms of operation currently. Mostly those that call full-time members who they've always nominated in that particular regard. So you don't just want any other member who is a public service to submit the application and then be part of the board. I think that's basically that what you look at. And if you look at, for example, clause 9, 5B, is that it talks to those people, the board itself must act independently with unfettered discretion, exercise independent judgment, and take decisions in the best interest of the public with regard to that particular one. So we don't see any problem with regard to that. Check. I don't know if the Ms. Floodbaum wants to add, maybe in terms of the comment.
Ms. Floodbaum?
That's the correct
Thank you, Chair. Yes, Chair, the overall responsibilities of the board members, the reason why they are coming on the board is because of the knowledge and expertise that they're bringing from those particular industries from which they are appointed. So like I said earlier, like what the department said, like the importance is that is the knowledge and the experience and what they would represent, that is what they would represent on the board. And all of that comes from the industries, the applicable industries, whether it is from labor, whether it is from the security industry of SAPs or so forth. So they bring all that knowledge and skill because they are aware what is facing those industries. So that is the overall criteria, I would say, Chair. But on what the other member was saying is that there won't be a problem with regards to members from COSATU who are possibly public servants or so, because clause 15D say, other than persons contemplated in section 10(2) C to E. So all other public servants are excluded except those members that are listed under clause 10(2) C to E, Chair. So that won't be a problem if you do have a person, for instance, from labor that's a public servant, because that would be the exception. Thanks, Chair.
Thank you. I hope that clears the air, Honorable Khai.
Yes, indeed, the Chair, as long as those will be allowed to participate in the board, irrespective of their status. Yes, I do take the rationale. Also, I think also that was a concern of Comrade Parks, the rationale of excluding those who are covered by the Public Service Act. But I think the response was that you don't want to have many people from the public service being part of the board or from government. I take that point, but also I take the point that some clauses also have exception with regard to those that are represented by the sector in which they come from. Yeah, thanks.
Thanks, Honorable Khai, for the feedback from the response that was given by both Mr. Mokaipi and also Ms. Floodbaum. Members, I believe that we have reached the end of today's agenda. We will proceed next week with the negotiating mandate, and also, but before that, we'll give an opportunity to the parliamentary liaison officer just to give to get the comments across. I believe what they will do, they will complete that matrix that we received. Like as Honorable Khai indicated, it was a bit late, but I think what is quite important is at this point we had an opportunity to get the views from our stakeholders and the response from the department to the views expressed by them. And then next week it will be the negotiating mandates, and probably then thereafter we will then wait for the final mandate and then take the matter. Of course, like as indicated, we operate under extremely difficult time pressure. But what is quite important is to make sure that whatever we do is within the context of the ambit of the law, making processes, because we have a responsibility to make sure that the laws that we pass as the National Council of Provinces is fully within the confines of what is constitutional. Hence, it's important that the interface between the department's response, the Office of the Chief State Law Advisor, and the Parliamentary Legal Office, there is convergence in terms of the product that we finally take to the plenary. So, having said that, honorable members, we will also defer the minutes of the last meeting to the next meeting, and therefore allow me to take this opportunity to express a word of gratitude to yourself, honorable members, for having found time, despite the campaigning, the election work that we assist with, to be able to make sure that this meeting becomes a success. To the critical stakeholders that took advantage of the invite that we extended, also our appreciation to your participation, and to the department to taking time to respond to the views that were expressed by our stakeholders, and also the rep from the Chief State Law Advisor, Ms. Grootboom, our appreciation, our staff for the preparation that they put into this meeting must be appreciated, and also the public at large for being part and parcel with us through our media streaming channels. Allow me then to formally close this meeting. The meeting is adjourned.
Thank you, Chairman.
Good afternoon, members.
Thank you.
Recording stopped.
Thank you, Chair.
Thank you very much, Mr. Chair.